Attorney General of the Republic of Trinidad and Tobago, Professor Rosemary Bell Antwine, Pro Vice Chancellor and Campus Principal, and other members of the Campus Executive Management Team, Dr. Alicia Elias Roberts, Dean of the University of the West Indies St. Augustine Faculty of Law, Ms. Evelina Melbazd, Deputy Head, EU Delegation to Trinidad and Tobago, Honorable Judges of the Caribbean Court of Justice, Honorable Judges of the Court of Appeal of the Republic of Trinidad and Tobago, Honorable Judges of the High Court of Trinidad and Tobago, Dr. the Honorable Justice Anthony Gafour, Chairman and Chief Judge of the Tax Appeal Court of Trinidad and Tobago, Ms. Chantal LaRoche, Clerk 3 of the Senate of the Republic of Trinidad and Tobago, Ms. Haseen Sheikh, Senior Counsel, Chief Public Defender, Mrs. Lynette Sibaran Sweet, Senior Counsel, President of the Law Association of Trinidad and Tobago, distinguished speakers and presenters, specially invited guests, members of the media, ladies and gentlemen. Good afternoon. I am Shivanjali Ramutar, lecturer at the Faculty of Law, St. Augustine, UE St. Augustine campus, and I'm honored to be chairing the second CCJ Symposium on advancing the case for regionalism and Indigenous jurisprudence. Welcome again. If you can please join me as we stand for the national anthem, please. Ms. Grace Bagwandine, lecturer at the Faculty of Law, St. Augustine campus, who will be delivering the welcoming address on behalf of our Dean, Dr. Alicia Elias Roberts.
Thank you, Chair. All protocols observed, good afternoon. It is my distinct honor and privilege to deliver the opening address on behalf of our Dean of the Faculty of Law at the UE St. Augustine campus, Dr. Alicia Elias Roberts, who is present here with us today, but is currently recovering from a minor surgery. You are warmly welcomed to this important second CCJ Symposium to mark a momentous event, the 20th anniversary of the establishment of the CCJ. I am very happy to once again be involved in organizing a CCJ Symposium at the Faculty of Law. The first symposium was hosted by the faculty 10 years ago when the current campus principal was the dean of the Faculty of Law and I was the deputy dean. I am pleased to once again support this worthy cause. The Faculty of Law is very happy to be able to host this event in collaboration with the Embassy of Greece and the Law Association of Trinidad and Tobago. I also want to warmly welcome the online attendees and representatives of the UNDP and our UE sister campuses in Cave Hill and Mona. This symposium, with so many distinguished panelists and speakers on a topic which surely is one of the most important legal subjects in the region, the promotion of the CCJ as a final court of appeal to complete the exercise of sovereignty and self-determination, and to celebrate the CCJ in its 20th anniversary as a court that has come to symbolize not just judicial independence, but Caribbean jurisprudence, the rule of law, and sovereignty. For me personally, I've worked with the CARICOM Secretariat within the Office of the General Counsel as a treaty consultant. So I am well aware of the background negotiations that went into the agreement to establish the court. That was a long time ago. And as a lecturer in the Faculty of Law at the UWI, I have always supported the establishment of an Indigenous Caribbean court as the final court of appeal for the region. As such, now, as the Dean of the Faculty of Law, I will continue to enthusiastically embrace the Caribbean Court of Justice without reservation. This 20th anniversary milestone invites both celebration and reflection. For 2 decades, this court has shaped the development of Caribbean jurisprudence, affirmed the rights and liberties of our people, and demonstrated that our region possesses the legal talent, scholarship, and institutional integrity to uphold justice at the highest level. As a community of legal scholars and students, we are proud to witness and to be part of this journey. The establishment of this court was not merely a structural change, it was a historic expression of confidence in our own legal systems and a call to nurture a uniquely Caribbean voice in global legal discourse. But I must confess, as I stand here today, it is bittersweet that we are still in 2025, 20 years after the establishment of the CCJ, having to debate this issue. So far, only Barbados, Belize, Dominica, Guyana, and St. Lucia have acceded to the appellant jurisdiction of the CCJ. There are 12 signatories to the agreement establishing the CCJ, and the other countries, including Trinidad and Tobago, where the seat of the court is based, its headquarters being located in Port of Spain, have not yet acceded to the appellate jurisdiction of the court. This significant milestone is also a time to acknowledge the many individuals who contributed to the court's foundation: the visionaries, legislators, advocates, and educators who believed that the Caribbean could and should take ownership of its final judicial authority. We owe them a debt of gratitude. I would like to highlight the work of the late Sir Sridath Rampal, known for his reputation as a distinguished Caribbean man, had repeatedly raised the issue of deep concern to the citizens of our Caribbean community, who remain perplexed by the failure of the great majority of CARICOM states to access the Caribbean Court of Justice as their final appellate institution, instead of holding on to the Privy Council in London. Delivering the inaugural Juris Lecture of the Trinidad and Tobago Judicial Education Institute in 2011, Sir Sridath urged governments to put their legal houses in order and to act in a mature and creative way, to have the CCJ as their court of last resort and not prolong a colonial dependence on the Privy Council. If you can also permit me a couple minutes to highlight the work of our current campus principal, Professor Rosemary Bell Antoine, on supporting the establishment of the CCJ. Professor Antoine has not only pioneered legal education in the region, but she has always highlighted the importance of regional jurisprudence and the need for our own courts as part of the core curriculum of the LLB program. As an academic, she has promoted the need for such a court, and she has written several books, including her book on Commonwealth, Caribbean law and legal systems, journal articles, and made several presentations in support of the CCJ. I recall 10 years ago that she said that she was a little tired, that we should still be talking about or trying to persuade anyone about joining the appellate jurisdiction of the CCJ, instead of simply gathering here today to celebrate with great joy the 10th anniversary of the establishment of the CCJ. Imagine now, 10 years later, we are still with this debate. I think when we hear from my dear principal next, she will be feeling drained to deal with this issue yet again. It is also sad that this issue has taken on a political tone, with politicians flip-flopping on the issue in the region. 2 months ago, the outgoing Prime Minister, Dr. Keith Rowley, had called on Trinidad and Tobago to complete its independence by severing ties with the United Kingdom's Privy Council and adopting the Caribbean Court of Justice as the nation's court of appeal. He said, "It is unjust, it is disgraceful that they would disregard our wider national interests, put a fee on us, and tell us, while you have to come to us to have our law lords tell you what is right and wrong, you have to pay for a visa to come and do that." I would add my own word of caution, that it is a matter of grave concern that a sovereign nation's apex court is in a foreign jurisdiction where the foreign state can unilaterally decide that they will no longer deal with your appeals because of inconvenience, economic considerations, or other factors. To move from gloom to positive thinking, I think that the very fact that we have such a show of interest in the gathering here for this symposium is a testament that we are prepared to seriously discuss the issues that have caused some delay in Trinidad and Tobago acceding to the appellate jurisdiction of the CCJ. The objective of this symposium is to create a forum for various leading legal minds to share their perspective about the role of the CCJ in both national and regional contexts. While I have my views, and I am open to hearing other perspectives and the views of others who may be concerned about the CCJ, and I hope that you are all willing to hear all other perspectives. Throughout the symposium today, we will hear from eminent legal jurists, legal practitioners, and scholars who have shaped and studied the court's evolving legacy. We will revisit landmark decisions, examine their impacts on legal doctrine, and engage in critical conversations about the future role of the court in a dynamic and ever-changing Caribbean region. To our students in the audience, I say this: you are the future of Caribbean law and justice. Learn from this legacy. Be inspired by the intellectual depth and integrity of those who sit on this court, and carry forward the ideals of justice, equity, and regional service. Before I leave, please allow me to make a pitch about our continuing and professional education, our CPE program. Each semester, the Faculty of Law offers CPE courses as standalone courses within the UE CPE framework. These are semester-long LLM courses where participants can apply to do a single course and will receive a postgraduate professional development certificate with academic credits on completion of the course. I think this will be of interest to our attendees here. Soon, we will offer a new course on Development Financial Institutions Transactions Law in Latin America and in the Caribbean, which will be facilitated by instructors from the IDB, and an internship will be offered to select participants. Also, regulation and governance of data and artificial intelligence is a new course that will be offered soon. So, on behalf of the Faculty of Law, I thank everyone here for your presence and your participation. We are deeply honored to host this celebration in collaboration with the Greece Embassy and the Law Association of Trinidad and Tobago. And we look forward to the rich discussions and reflections that will emerge over the course of the afternoon. Once again, welcome, and let us together celebrate 20 years of regional judicial excellence. Thank you.
Thank you, Ms. Bagwandine. I now invite our principal and Pro-Vice Chancellor, Professor Bell Antwine.
I know we were asked to go with the moderator's salutations. Usually I'm very obedient, but I can't not acknowledge our Honorable Chief Justice, Mr. Ivor Archie, who's here with us. He's actually a great friend of the faculty throughout the years. Thank you so much, sir. And of course, our new Attorney General, Mr. John Jeremy S.C., who I don't know if you were aware that not long ago he was a member of staff. You know, I was his boss, but not anymore, right? And of course, we have also several members of the judiciary, including the highest court that we're talking about here today, the CCJ. Welcome, Justice Rajana, Justice Ojunji. I don't know how to pronounce it, it's not written here, but welcome to Trinidad and Tobago, all of you who have come out this evening this afternoon to be with us. Thank you so much on this very special occasion to bring greetings at the second Caribbean Court of Justice Symposium on advancing the case for regionalism and indigenous jurisprudence. As you heard, we had the first some years ago, 10 years ago. I was actually trying to remember the date, when I had the pleasure of organizing that one, the inaugural symposium, and of course, my then deputy dean, who at the time was more into international law and oil and gas law, but now she has to wear several hats, not so dean, and represent all disciplines. But I have to keep pinching myself to remind myself that today I'm not here in my capacity as former Dean of Law, nor even as a legal scholar. I'm here rather to greet you as the campus principal, so I will leave the heavy legal edification to the capable presenters who will come after me. But I really do want to thank the Faculty of Law under the excellent stewardship of our Dean for the great work that they are doing, and they're continuing to lead the legal fraternity in critical discussions and programs. Those were two exciting ones that you just announced, being quite innovative and ensuring that they keep the pulse of the legal community well in train. And I also want to extend my sincere gratitude to the Law Association of Trinidad and Tobago, We have with us the indomitable president, Lina Sweet. I saw her a while ago. Another friend of the faculty, in fact, and the Greek embassy for partnering with us in this symposium. The faculty's objective remains, as I think I can say, the objective of the entire campus and the University of the West Indies, because we are rooted in development and regional development, and that objective remains to foster positive debate on the possible accession of Trinidad and Tobago to the CCJ as the final court of appeal, and more so to promote educational awareness on the role of the court in general. And we know that the CCJ plays an important role in developing regional jurisprudence, and this symposium will explore that while examining the experiences of other Commonwealth jurisdictions that have abolished the Privy Council as their final court of appeal. Just as we did in the first symposium, at that time we had jurists from India, from Canada, from Australia, and so on. And it was very interesting to hear the similarities in the kinds of issues that confront us. Of course, they moved ahead and were able to confront and overcome those challenges and issues, whereas we have not so much, some of us. So there is inevitably, though, a sense of déjà vu for me. As you heard, this is a topic I've been exploring for a long time. As you also heard, I am very drained and very tired of this debate. I don't think it's an exaggeration. Justice Rajan and I were just reminiscing that how many years ago, who would have thought that we would still be discussing this, but discuss it we must, and overcome it we must. And recently I was also asked to speak on it for the first time in several years, I would think, to revisit the issue when I spoke at the launch of Justice Gafour's and Dr. Indira Ramprasad's book on the CCJ, the jurisprudence of the CCJ and regional integration, which is an interesting and different slant to the discussion. I was actually Justice Gafour's PhD supervisor, which is why I was asked to speak then, and that led to that work. I've often said that the CCJ's ability and willingness to create an indigenous jurisprudence, adapting to our own local circumstances, genuinely reflecting our social realities, without, of course, sacrificing appropriate legal principle, has been and continues to be a long-cherished goal of legal scholars like myself. And I still see, and I still have faith in the potential for Caribbean revolution in legal development. And there is an opportunity to create an independent legal philosophy. Not necessarily an independent legal tradition, although we wouldn't rule that out, but certainly a legal philosophy, while forging ahead to establish a united Caribbean identity. But to do that to the max, I think we do need to have the fullest or fuller participation from the countries in the region, and we really have to applaud those countries that took the leap of faith. In particular, Guyana and Barbados, the first two, I've always admired, that they just went for it. So we know that all of the independent Caribbean countries, except the Bahamas, do accept the original jurisdiction, but we continue on for those others to join the momentum in relation to the final court of appeal. Those that have not done so, they continue to cling to this imagined concept of impartiality that apparently can only emanate from the Privy Council and the sound decisions that apparently only emanates there, despite ample evidence now after 20 years, is it, proving that the CCJ has met all of the tests and more that we have asked of it. I should add that in the current economic climate that we live in, where protectionism seems to be lauded over free trade, I think this suggests that we need to revisit the notion of regional integration. I know that's a big topic for this symposium today, and the CCJ does stand as a mechanism to help realize that vision, offering legal coherence and institutional support for a more unified Caribbean. So as countries, including Trinidad and Tobago, continue to grapple with these issues surrounding the CCJ, I urge policymakers and those in government to revisit the debates and decisions. There's no doubt that the Privy Council is a relic of colonialism, one that we need not take into our future. We can have a future that will be shaped by the wisdom of the choices that we make as we define our place in the world. And as you've heard and you will hear often today again, the CCJ remains, and it is the embodiment of independence and sovereignty. And these are principles that every society must uphold. Additionally, an often overlooked but vital benefit that the CCJ offers is its ability to widen access to justice across the region. Access is a very important concept to our countries and to this country, whether it's access to education, which this university continues to work towards, or access to goods and services that countries and this country strives toward. Access is just as important. And the Privy Council, of course, being geographically distant and the rules that surround it, is less accessible than the CCJ, not only because of the new visa, yes, that's important, but also the costs. And there's no doubt, and the statistics prove, the increasing workload of the CCJ, which you can easily see if you go on the website. I think it proves that we are making a dent in terms of access to justice for our people. And also an important point, as CARICOM deepens ties with neighboring countries in the region, going towards trade and other reasons, the role of the CCJ is even more critical. Our deepening relationship, for example, with Latin America, that is important because it underscores the necessity of having a legal institution capable of engaging with diverse legal traditions. And in fact, from the onset, that was one of the strengths of the CCJ. Unlike the Privy Council, they made a conscious effort to include a Dutch judge for that reason, so that we could have a jurisprudence in a hybrid space where civil and common law legal traditions intersect. That's a very important point about it, and it's inherently Caribbean. And this is where I think sovereignty in law and strength would lie going towards the future. When it was inaugurated, since it is a celebration and anniversary 20 years ago, then lead Prime Minister for the CCJ and Justice, someone I know fairly well, Dr. Kenny Anthony, who spoke, reminded Caribbean people, and these are words that are quoted almost every speech about the CCJ. We remember these words about the leap toward enlightenment, that speech. But one of the points he made, that the region's legal profession and judicial system had a glorious past, amongst the strongest in the Commonwealth for 3/4 of a century. He was making the point that we devalue this contribution and our own contribution to the Privy Council itself, so that not just our excellent judges who have served all over the world, including in Africa, as you would know, Justice, but he recalled the distinguished contributions all over the Commonwealth. We've had chief justices sitting in Africa, for example, and at The Hague, International Court of Justice in The Hague, and other international tribunals. And he remarked that in per capita terms, quote, "I doubt if any other community in the world has served the worldwide cause of justice more comprehensively and more consistently than has the Caribbean, unquote. And former president of the CCJ and former Chief Justice Ilhabastide made a related point about the fact that when these wonderful judgments come from the Privy Council, and we applaud them very often, they're adopting judgments that come from our own local courts and the work that went in. So these are important points for us to remember as we move forward. So I hope that, the fears, all of these things will be discussed today. There's a lot to discuss. But with this in mind, I want to thank the Faculty of Law once again, specifically the Planning Committee, led by Dean Elias Roberts and Dr. Timothy Afonso, for their work in organizing this symposium. And I want to thank all of our partners and our panelists for contributing to, yes, we're talking about it for a long time. Yes, some of us are tired, but it still remains a vital and a very important discussion and issue. And I have no doubt that these issues will be thoroughly ventilated with great erudition and learning at your conference. To my CCJ colleagues, including, I see some of your staff here as well, Ria and others, not just the judges, happy 20th anniversary. To the rest of you, I want to urge you, especially the young of you and the young in spirit, remain energetic, keep up the struggle, congratulations and best wishes.
Thank you, Professor Rosemary Bell-Antwine. I'd now like to invite the Honorable Madam Justice Maureen Rajnath Lee, Judge of the Caribbean Court of Justice, who's representing the Honorable Justice Adrian Saunders, President of the CCJ, to now make her opening remarks, please. Thank you, Judge.
Good afternoon to everyone. Honorable Chief Justice, thank you for being here. Honorable Attorney General, congratulations, and thank you for being among us today. It's greatly appreciated. My new brother judge, Justice Chile Ebo Asuji. Welcome, sir. And welcome to all the honorable judges of the Judiciary of Trinidad and Tobago. Principal, thank you for your warm comments. And to your Dean, Dr. Elias Roberts, Dean of the Faculty. Thank you to your team for sponsoring and hosting this second symposium. I missed the first one just by a couple months because I was appointed soon after, but I understand that it is still talked about today. Thank you for inviting the President of the Court to bring some opening remarks. Unfortunately, he could not be here with us today, but he has asked me to extend his heartfelt gratitude for the continued support this faculty has given the court over the past 2 decades. Thank you. I wish also to acknowledge your sponsors, because we don't do this with our generous sponsors, so thank you to them. As I prepare these remarks, I was reminded of my own journey, beginning as a first-year law student right here at the Faculty of Law, UWI St. Augustine. I'm afraid to say it, but fast forward more than 50 years. I am now privileged to be part of another remarkable Caribbean institution, the Caribbean Court of Justice, which, as you heard, celebrates its 20th anniversary this year. It is worth noting that 6 of the 7 current judges of the CCJ earned their undergraduate law degrees at the University of the West Indies, and I think that needs an applause. Both our current president, the Honorable Justice Adrian Saunders, and our incoming president, the Honorable Justice Winston Anderson, are graduates of the University of the West Indies, Cave-Hill campus. That in itself speaks volumes about the strength and vision of Caribbean legal education. About the CCJ. The CCJ's mission is to provide accessible, fair, and efficient justice to the peoples and states of the Caribbean community. Its success over the past decades, in my view, rests on three pillars. The first pillar, a strong, independent institutional framework designed to shield the court from political and other external pressures. Two, a body of progressive, thoughtful judgments which have advanced the rule of law and deepened democracy across the region. And three, a committed and innovative staff, many are here today, whose work has enhanced access to justice and ensured the court's continued excellence. I wish to highlight that the CCJ is the first court in the Caribbean to be accepted into the prestigious International Consortium for Court Excellence. The CCJ has implemented important policies and protocols to better serve our internal and external stakeholders. And just a few I wish to mention today. A harassment policy, which includes sexual harassment. A policy to improve access to justice for persons with disabilities. An anonymization protocol, critical to protecting vulnerable litigants, especially those involved in sexual offense and domestic violence cases. And a 2025 practice direction on the use of generative AI tools in court proceedings, keeping the court at the cutting edge of innovation. I also wish to make mention of the work of the CCJ Academy for Law, the court's educational arm. This arm champions initiatives like the Eminent Caribbean Jurist Series, and I know many of you know about that series of publications and videos. And of course, the Needham Point Declaration on Criminal Justice Reform, advancing a modern criminal justice system in the Caribbean. I am pleased to report that CARICOM heads of government have recently pledged continued support for the Declaration's reform agenda. And so I'm not going to be long today because we have a lot to do, so I want to close by assuring you all the CCJ stands ready to serve as the final appellate court for all Caribbean states. We look forward to the day when all our member states fully embrace this opportunity. We urge you, as you sit here today, students, scholars, practitioners, other persons, to continue engaging with the court. Critique our judgment. Yes, look at them, give them a good look, critique them. Teach their significance and help us deepen public understanding of Caribbean jurisprudence. And I just wish to thank you again, Dr. Dean of the University of the Faculty of Law, University of the West Indies, St. Augustine, Dr. Alicia Elias Roberts, and your hard-working team for this opportunity to participate and for this wonderful symposium, which we all look forward to. Thank you so very much.
Thank you very much, Madam Justice Rajnath Lee. I'd now like to invite Mrs. Lynette Sibaran-Sweet, Senior Counsel, President of the Law Association of Trinidad and Tobago.
Thank you, Master of Ceremonies. As the fourth person to bring introductory remarks, it really does behoove me to have mercy on the gathering and to be as brief as possible. However, I must say that I deem it appropriate to acknowledge the great and good persons who are present with us this afternoon, in the persons, of course, the Honorable Chief Justice, Sir, Mr. Ivor Archie, Mr. John Jeremy, Senior Counsel, our new Attorney General, Professor Rosemary Bell Antwine, Pro Vice Chancellor and Campus Principal, my very good friend, and other members as well of the Campus Executive Management Team, Mrs. Roberts Elias, Dean of the Faculty, with whom the association was collaborating over the sponsoring of the organizing of the event, Ms. Mel Bazadi, Deputy Head, EU Delegation of Trinidad and Tobago, Justice Maureen Rajnath Lee of the CCJ, as well as to offer a personal word of welcome and a word of welcome on behalf of the Law Association to Justice Ibo Osuji of Nigeria, and to take the opportunity to mention that certainly Rosemary and I had the opportunity of meeting a great SAN of Nigeria at the Malta conference in the person of Mr. Osujwi, the current president of the Law Association of Nigeria. Judges of the Court of Appeal of Trinidad and Tobago, judges of the High Court of Trinidad and Tobago, Mr. Justice Anthony Gafour, who is going to be a panelist today, Ms. LaRoche of the Senate, Ms. Haseen Sheikh, Senior Counsel of the Chief Public Defender, distinguished speakers, specially invited guests. I would like to extend a heartfelt thanks to have been permitted the opportunity of bringing these remarks on behalf of the Law Association, whilst at the same time being profoundly aware of being at the head of a profession which is, shall we say, divided on the issue, and also being profoundly aware that I have been chided in the past in public on expressing my personal view on the question of the accession of Trinidad and Tobago to the CCJ. When one takes on the task of office, this sort of office, I think that one loses some of the freedom one has to express one's personal views. Be that as it may, LAT is proud to partner with the Faculty of Law, UE, on this second occasion of the holding of this symposium. We acknowledge the great significance of the topic and likewise anticipate with great excitement the discourse to follow. The CCJ remains one of the few bastions of true regional integration and represents one of the only institutions of solidarity for a people unified through our shared historical, socio-economic and political experiences, as we have already heard. The court is a pillar of justice and is revered for its unique role in developing regional jurisprudence. And we note that the judgments emanating from the court have helped to guide our CARICOM territories through their maneuvering of the revised Treaty of Chaguaramas in its original jurisdiction. In the same vein, we are profoundly aware of the spirited pronouncements of the court and of its role, well, in its role as a finite appellate court for the other territories in the region, Barbados, Belize, Dominica, Guyana, and St. Lucia, that have made the bold step. And the elephant in the room really is whether, or rather when, the other territories would take that leap of faith. We appreciate that this has become a polarized topic among some quarters, and there are those of us who have not been timid to voice their support either for or against accession to the CCJ. LAT recognizes that regardless of the particular stance that one adopts, it is an important stakeholder, the organization, and should take a leading role in educating the public at large about the pros and cons of either decision on the question of making the CCJ the final appellate court. It is the public, of course, who will be the ultimate patrons of the court. If we are inclined to believe that the Judicial Committee of the Privy Council is the better of the options because its judges are far removed from our people and less likely to be influenced by local considerations, let us also appreciate how this can equally stagnate the development of our indigenous jurisprudence. If we can't trust our judges to make final decisions, then should we trust them to decide matters in the lower courts? That's the question. Similarly, if we are pro-CCJ, because we're of the opinion that it speaks to our sovereignty as independent nations, let us also then consider the rebuttals of our distinctive identities as Caribbean peoples and contemplate whether we are simply suppressing our national potential at the cost of advancing the case of regionalism. Is this sovereignty, or are we simply exchanging a foreign non-national court for a regional non-national court? Attendees, I'm sure our panelists are going to deliver some thought-provoking insights on this topic, and it is my fervent hope that we may all benefit from fruitful engagements throughout the day's presentations. I wish to commend the Faculty of Law for providing this much-needed platform. And I also want to take the opportunity to extend our profound congratulations to the CCJ on having achieved this anniversary. May it long continue to advance Caribbean jurisprudence and make its distinctive mark in the judicial realm. Thank you.
Thank you very much, Ms. Simaran Sweet. I believe that brings to an end our opening remarks. Before we dive into our panel discussions, I would like to invite you to scan the QR codes that are on your table, and it will take you to a revised program, as well as the biographies of the speakers and their abstracts, which you can enjoy as the panel's discussion begins. With that being said, I'll now introduce Dr. Emma Perot, lecturer at the Faculty of Law at the UWI St. Augustine campus. Our first moderator for the panel discussion is CCJ and regional integration.
Good afternoon, everyone. All protocols observed. I would like to invite the panelists to join me on stage, please, for our first panel, the CCJ and regional integration. We'll have 3 speakers for this panel, Dr. Gafur, Dr. Yearwood, and Mr. Jagru. This panel will last an hour and will be followed by a question-answer segment. And during that segment, we will have mics in the audience, so we hope you will engage with us. While my colleagues are settling on stage, as this is a great opportunity to promote the faculty, I would like to let you know that we have a journal here at the UWI St. Augustine Faculty of Law, and we have a special call out right now focusing on the CCJ. So if you go to our faculty's website and you look up our journal, that is the UWI St. Augustine Faculty of Law Journal, you can see our special call out. It is due in June. And I'm sure if you're attending here, you probably have some thoughts that you might like to share with us in this journal. So without further ado, we will start with our first speaker, Dr. Gafur, who will be speaking on the potential of the Caribbean Court of Justice to foster regional integration.
Okay, tell me when you're ready. So, good afternoon, ladies and gentlemen. It's a pleasure to be here, and I'm told that one of the things that is often exchanged and on the 20th anniversary is China. And unfortunately, I didn't bring any China with me. And of course, we're talking about China the porcelain, not the country. Although, of course, these days with threats of annexation of various jurisdictions, you never know. But the point is that it's a pleasure to be here. And I also particularly want to acknowledge, as has been said before, not just the Madam Moderator, but of course the Honorable Chief Justice, the Honorable Attorney General, judges of the Caribbean Court, Madam Justice Rajnath Lee and Justice Ibo Suji, as well as, of course, the principal of the and Pro-Vice Chancellor of UWI St. Augustine campus, Dean of the Faculty of Law, Dr. Alicia Elias Roberts, fellow panelists, as well as, of course, this very distinguished gathering. So my presentation really is going to focus on the question of the ability of the Caribbean Court of Justice and its potential for regional integration. And I want to start off by giving a very brief overview. My presentation will really fall into three parts. The first is really looking at the Caribbean Court of Justice and citing it in the international arena, the original jurisdiction of the court, and then, of course, the appellate jurisdiction, and then just to give some very brief conclusions thereafter. So just starting off then with the CCJ in the international arena, if I can, I don't know if there's a first slide that can be put up. Essentially, one has to recognize that the Caribbean Court of Justice is a product of globalization emanating from the 1990s, and that brought with it certain characteristics, including trade liberalization, free movement of persons, goods and services, and the distribution of labor and capital. And this resulted in an increasingly integrated approach to the international system through the emergence of various regional blocs. These included, of course, most well-known or most famously, the European Union and NAFTA. I'm not sure where NAFTA is these days, given the recent pronouncements from the US, but certainly that was considered a fairly prominent regional bloc when it was created between the US, Canada, and Mexico. And these issues have given rise to a growing number of conflicts and regional disputes which have emerged against the backdrop of proliferation, I should say, of regional agreements, of which there are now hundreds around the world. And of course, as a result of that, and inevitably because of the likelihood and the possibility of conflict, it's also given rise to the need to have courts that can help to resolve those disputes. And in fact, if one compares the origins of our regional movement with CARIFTA, for example, we didn't have provisions for a dispute resolution body. Now we do in the context of the Caribbean Court of Justice. Now, briefly, if I look at some of the regional blocs that exist in Latin America, there's a whole proliferation of them. They're listed here for convenience, and they start with the Latin American Free Trade Association, and you go down the list, Central American Common Market Nations, the Bolivarian Alliance for Peoples of the Americas, Association of Caribbean States, CARICOM itself, and of course the CSME. And all of these regional blocs have a critical role to play in terms of not just fostering this idea of regional integration, but also trying to bring together the peoples of their respective constituents. And I think that the role of the CCJ, I would suggest, is no different. The idea is that it is a unifying force among other factors. I want to mention, of course, the West Indies cricket team, but that may or may not provoke some comfort or otherwise, depending on how one looks at it. But certainly, in terms of courts themselves, one can look at the list that is set out here. Principally, for example, the Court of Justice of the European Union, and then, of course, there's several others, Economic Community of West African States Court of Justice, the Court of Justice of the Andean Community, which actually bears close resemblance and similarity to the CCJ. The Eastern African Court of Justice, the Central American Court of Justice, CCJ itself, and then, of course, further afield, the International Court of Justice and the International Criminal Court. So it's important to recognize that the CCJ over the last 20 years has truly earned its place among these distinguished courts and tribunals. And there can be little doubt, not just in terms of the quality of the judgments, but also in terms of the ability, as was mentioned by Madam Justice Rajat-Lee, to liaise in promoting educational opportunities for jurists and attorneys and other interested parties, but also providing that unique function that really the Privy Council, with respect, cannot provide and does not provide. So if we look initially then at the concept of regional integration, what are we actually talking about? Well, I mean, the first generation of rights really focused on economic unity, but the second generation, which is what I want to cite the CCJ in, embraces a far more multi-dimensional approach to integration. It includes not just the economic, but the political, the social, and cultural aspects, and therefore it goes well beyond the initial sense of fostering regional integration. And of course, this is what ultimately led to the formation of the Caribbean single market and economy, which continues to have unrealized proposals even for common currency, but something that I think perhaps needs to be looked at very, very closely in terms of, if we're really going to talk about regional unity and regional integration. So looking at, for example, some of the other regional blocs and what their experiences have been like, we've had, of course, several emanating from Africa, including bodies such as the Common Market for the Eastern and Southern Africa, Community of West African States, Eastern African Community. And in Asia, you've had the Association of Southeast Asian Nations, South Asian Association for Regional Cooperation, and the Indian Ocean Rim Association. Some of these, of course, may be less well known. And of course, not only do we have the creation of these various regional blocs, but we also have the creation of various regional courts, some of which I've already highlighted. And of course, all of them play a critical role in terms of the resolution of disputes. And I should also put in a plea here, because it's not all about litigation, but in fact, the conference that I had the pleasure of convening back in October at this very venue, as chair of the Chartered Institute of Arbitrators, one of the things that we focused on was the use of dispute resolution. And in fact, if you look at the RTC and other underlying documents, you'll see that part of the thrust, part of the remit of the CCJ is to promote alternative dispute resolution. So it's not just all about litigation, and I think it's important because that aspect is not always emphasized as much as it should be. Now, many of you will be familiar with the movement which led to the creation of the CCJ. It really started, if you like, with the 1919 West Indian Court of Appeal, but more recently focused on the court created under the auspices of the West Indian Federation from 1958 to 1962, and then thereafter CARIFTA, CARICOM, and of course more recently the CSME. But of importance are two critical reports. One is the 1990 Gladstone report, where Sir Roy Marshall and the West Indian Commission report in 1992 had made calls for a regional court. Of course, this is a movement that went back to 1901, as is well known, in an article in Jamaica Gleaner, where there were calls for such a court even in those days. And here we are in 2025, still, as was said, debating this issue. So when we talk about regional integration, we're really focusing on the CSME for all practical purposes. The agreement that was signed, CSME in 1989, includes most of the CARICOM countries, not Bahamas, but many of the other prominent ones. And the whole purpose behind this is to encompass non-economic goals such as human rights, security, and culture. And it's interesting because if you look at the jurisprudence of the CCJ, the judges, I'm sure, will be the first to say we're not a court that really specifically deals with human rights or even taxation or these other areas. And yet still, many of those judgments have actually touched and concerned in very, very strong ways these various areas. So this concept of the new regionalism, of which the CCJ is a product of, really gives rise to hopefully binding treaty obligations, some of which are enacted into domestic law via domestic legislation. We certainly have that for the original jurisdiction, and as we've heard, for 5 of the existing CARICOM states, but not the others as yet. And so the end result is that the creation of this court is set to promote both economic and non-economic benefits. And of course, it's also important to highlight the fact that the CCJ is unique among regional and indeed international courts in having that twin objective of both resolving appellate disputes, where it's the final appellate court for 5 jurisdictions, but of course the final court, and arguably almost like a court of first instance for regional economic disputes under the original jurisdiction. And this is certainly derived from the preamble to the Constitution, so to establish the treaty establishing the CCJ. Where that singular role of the original jurisdiction as being essential for the successful operation of the CSME is articulated, as well as the preamble to the RTC, which echoes the sentiments expressed in the Declaration of Grandance and other decisions of the Commonwealth heads of government. Shortly, I'll be talking about the Myrie decision, which actually was a product of the collective thoughts of the head of government, which really gave rise to one of the preeminent forms of litigation and indeed cases before the CCJ. So let me turn now quickly to the original jurisdiction cases, and this will just be a cursory examination of some of the leading ones. They're highlighted. They're possibly too small for you to read, so we do apologize for that. But I'll just touch on a couple of them. Hummingbird Rice Mills, for example. This illustrated the ability of the CCJ, which granted special leave to begin proceedings arising out of the non-imposition of the common external tariff. In Rudisa Beverages, we had an example of the CCJ acting in the economic context where it found that Guyana had breached Articles 78, 79, 87, 90 of the RTC, where that jurisdiction had imposed an environmental tax, and that was seen, of course, in essays as a barrier to trade. We had SM Jalil, where the CCJ held that the tax was discriminatory in terms of an import duty in breach of Article 87, and of course the all-important Shanique Myrie case, where the CCJ focused on the ability to promote free movement of persons, as well as functional cooperation, and the not always emphasized objective of social integration. Of course, we also had illustrations of that in other similar cases, such as Tomlinson, someone who was never denied free movement as a member of the LGBTQI community, but the CCJ held that the archaic immigration laws of Trinidad and Tobago and Belize should be amended. And then, of course, the well-known case of Jason Jones and the Council of Legal Education, which also focused on the right of a non-UE graduate to admission to pursue the legal education certificate at our local law school. So these cases essentially underscore the economic and non-economic thrust of the CCJ's jurisprudence in its original jurisdiction. It also underscores the principles emanating from the jurisprudence of the original jurisdiction and advancing free movement of goods and persons, all of which I would say are essential elements of the CSME. So what are the key enablers to regional integration? Well, both my study, my thesis, has given rise to identifying 5 key principles, and again, I'll touch on these very, very briefly. The first is the concept of supranationalism. And in that regard, what we see is that you have the coalescing of nations for the purpose of creating an institution, organization, or treaty which has greater powers than the individual nations because its reach extends beyond national boundaries. Something that in many ways the Europeans had gone through with a concept called subsidiarity. But the general idea is that it exercises that function through both the appellate and the original jurisdiction, as well as emphasizing the financial independence and that it enjoys in the appointment of judges through the regional judicial legal Commission. And then, of course, Article 222, an all-important provision of the treaty, which really is quite unique because it gives individuals and private entities direct access to the CCJ upon seeking special leave. So these, together with the ability to determine the standard of proof and even to sanction the use of interveners, as well as the mandatory referral provision of Article 214 of the RTC, gives rise to a whole swathe of rights that are inured to individuals as well as private entities such as corporations. And it's interesting that there has been 100% compliance with its decisions, including the payment of damages by the parties. The second enabler to regional integration, which the CCJ is able to promote, is through the concept of binding precedent. And this is encapsulated in Article 221 of the RTC, which states that judgments of the courts are to constitute stare decisis or binding precedent. This is a radical departure, and I emphasize that, a radical departure from the rules of precedent in international law. And in that context, the original jurisdiction of the court, it acts as a regional international court, and there's no hierarchy and so on in national law, but quite uniquely, the ability to be bound by its decisions and indeed to have that influence other jurisdictions within the Caribbean and even further afield, I think is important to emphasize. So Justice Pollard, one of the early pioneers, former legal advisor, to CARICOM, and of course later quite famously as a judge and of the Caribbean Court, asserted that drafters deliberately intended this radical deviation or innovation from the traditional meaning of stare decisis to advance regional integration. Again, a concept that I was able to explore in the thesis, but also something that I think needs to be given greater emphasis. And so while the CCJ may not necessarily be circumscribed by the rules of precedent, it will follow the dictates of international law with regard to that, and it very often does refer to decisions of the World Trade Organization or the Court of Justice of the European Community or other relevant and high-standing courts in terms of guiding its decision, even decisions of the Privy Council. And it's interesting to note, in fact, the Privy Council has also adopted some of the CCJ decisions, so it's a two-way process, and I think it's important to remember that. Third enabler to regional integration is the concept of binding decisions, and that is distinguishable from binding precedent because essentially it means that the CCJ is bound by its own decisions, although it may depart from it where appropriate. And this is encapsulated in the RTC Article 219 and Article 22 of the agreement establishing the Caribbean Court of Justice. What emerged from the case of Jason Jones, for example, was that the court said this: judgments of the court shall constitute legally binding precedent for parties in proceedings before the court unless such judgments have been revised. And so the CCJ decisions do bind parties to proceedings to the CCJ's own previous decisions, even if you are not immediately a party to that other decision. CCJ is also at liberty to depart from past decisions if the facts so warrant. And of course, the decisions do bind the contracting parties or member states, as well as, of course, giving rise to decisions of the heads of government conference, which was encapsulated in MIRI. In fact, I was very gratified to see in my attendance at a course in Switzerland not too long ago that the idea of MIRI and the ability to ensure that there was a hassle-free movement within the region was something that gained the attention of the International Law Commission, that august body that is quite, responsible for the development of international law, certainly at the global level. And so we see the decisions of the CCJ resonating not just within the region, but far outside the region and other jurisdictions. And I think it's important to note that. The other enabler that I want to touch on is the idea of compulsory jurisdiction. And this is a situation where Article 211 of the RTC, entitled the court to act in certain contentious proceedings. And we have this, of course, illustrated in various ways too. Article 16 of the treaty establishing the CCJ also established that the court has jurisdiction where there are issues of supranationalism. And again, there was some debate over that. Justice Pollard took the view that it wasn't a supranational institution. I've taken a different view, and others have as well. So the point is that these decisions do have a wide-reaching impact. Very quickly, as I wrap up on the question of the original jurisdiction, the exclusive jurisdiction, which is encapsulated in Article 13 of the agreement establishing the CCJ, provides that the court shall have exclusive jurisdiction to deliver advisory opinions concerning the interpretation and application of the treaty. And this suggests that contracting parties to the RTC must take to the CCJ all matters which fall under the treaty. And in fact, this is an area that is not used sufficiently together with the reference provision. I mean, we've had other distinguished academics. I can mention Professor Alina Kaczorowska, who wrote an excellent book on the reference provision, and it was also the subject of a thesis recently, suggesting that because of Article 222, which gives the ability to access the jurisdiction of the CCJ by private parties and private litigants, perhaps insufficient use has been made of Article 214. But it may be in due course that that is something that can improve. And the CCJ has itself taken steps to try to ensure that that can be promoted. Professor Carnegie, one of our great academics, had underscored how this doctrine of exclusive jurisdiction forces another party to the CCJ's jurisdiction and, of course, restricts its ability to go elsewhere. And this actually departs from customary international law, where the jurisdiction of an international court requires the consent of both parties. And then the compulsory and exclusive jurisdiction, another enabler of regional integration, gives that important jurisdiction to the CCJ in its original jurisdiction when it comes to dealing with both advisory opinions, but also in terms of more contentious proceedings. All right, well, I will have to move on fairly quickly. There was much more to say, but I'll move on fairly quickly to dealing with the appellate jurisdiction, which of course excites a lot of attention given that we still, particularly in Trinidad and Tobago, Jamaica, and other jurisdictions, have retained the Judicial Committee of the Privy Council. So in that context, the appellate jurisdiction is something that contributes significantly to unique characteristics. I had argued in my thesis that you need to have both the original and the appellate jurisdiction to promote regional integration, something that I do not believe has really been argued with any real force in the past. And in doing so, one can look at, for example, the ability of the CCJ to articulate on important constitutional rights, including fundamental human rights, property rights, land rights, and good governance. And of course, this also it means that, for example, many criminal cases raise important constitutional points, and also gives rise to critical decisions when it comes to constitutional interpretation. And this, to me, has been a really original contribution of the CCJ towards regional and international jurisprudence. I mean, time doesn't permit me to go into the nuances of Caribbean constitutions, but you have some of the points listed on the slide here, where it is adopted. I think the first president in the TCL decision, Honorable Mr. Justice de la Bastide, had emphasized in that case the importance of a liberal and purposive approach towards constitutional interpretation and treaty interpretation. It also sought to reject the idea of endemic delay in delivery of decisions, something that has incurred the wrath of some Caribbean politicians. But of course, all importantly, the savings law clause has been an important aspect. And more recently, we've seen in certain cases where the court has sought to restrict the use of savings law clauses, particularly where it may work an injustice with regard to human rights, something that I know is attracting the attention of the Law Association even as we speak. So those various principles as identified here, I think, help to illustrate the importance of this. I can particularly mention the case of Attorney General in Barbados and Joseph and Boyce. There are several others, of course, where in that case, it exemplified the phenomenal contribution made by the CCJ in assuming a more liberal and purposive approach to constitutional interpretation, which recognized the significance of the preambles of Caribbean constitutions. And I think that case, albeit arising in the criminal context, was one that I think has also been of enduring appeal, together with, for example, the case of Shanique Myrie and others. All right. Well, I think I will have to bring my presentation to a close. I've tried to touch on some of the more critical aspects of the CCJ's jurisprudence and the principles that have emanated from it. I'll just mention in passing the case of Quincy McEwen and the Attorney General, which, of course, had focused on discrimination being meted out from the use of old vagrancy laws in Guyana in 1893 to restrict members of the LGB TI community and so on. And Justice Saunders particularly affirmed in that case, he said, I could well see that this may have the effect of disabling entirely any harmful effects of the savings clause because if a litigant can establish that a fundamental right promised by the Constitution is denied because of the existence of the savings clause, then the litigant may well argue that such a state of affairs deprives her of her right to the protection of the law. There are other aspects dealing with separation of powers, but in conclusion, what I would like to say is this, and that is that we see that not only has the CCJ articulated a broad spectrum of rights, all of which touch and concern the Caribbean people, and of course, its decisions, as I've said, are impacting on other jurisdictions, but it has also indicated and demonstrated its profound appreciation of the principles of fairness, transparency, integrity, and proportionality, both procedurally and substantively. These are all ideals which it insists should be upheld by all member states. And this suggests that the CCJ is well poised to drive the regional integration process. So hopefully, for those of us who may or may not be here in about 20 years' time, we would no longer be having this debate. In keeping, again, with the concept and theory of neo-functionalism, something which pervaded the thesis, this was something that was revisited, in effect, through the new regionalism and sought to redefine the concepts of binding precedent and binding decisions. And it has demonstrated its ability not only as a supranational legal institution with compulsory and exclusive jurisdiction, but also its propensity to act independently of member states and also public opinion. And in that way, the CCJ has sought to establish a level of stability, certainty, uniformity, consistency, predictability, and even harmonization across the CSME, which, of course, all states, we believe, have an unceasing quest to foster regional integration. Thank you very much for your attention.
Thank you very much for that, Dr. Gafur. I love how you took us through the approaches to regional integration from the economic focus to the multidimensional approach. I know you said you didn't get to go in depth into the constitutionalism, but have no fear because our second speaker, Dr. Yearwood, is about to present on decolonial constitutionalism and judicial lawmaking, Trinidad and Tobago's Westminster system, and the Caribbean Court of Justice debate. So we'll be building very nicely on an excellent foundation provided to us. I now invite my colleague to give his presentation.
Good afternoon, everyone. I want to thank Dr. Elysius Roberts for having me here, and I bring greetings on behalf of the Dean of the Law Faculty of the University of the West Indies, Dr. Antonius Hippolyte. He sends his regards and he sends his congratulations to the Caribbean Court of Justice and obviously to the judges of the Caribbean Court of Justice. When I was preparing this presentation, I called Dr. Elysius, I called the Dean of the Law Faculty here because a quote came to mind. There's an old saying in Barbados, which apparently is in Trinidad, eggs don't go to big rock party. And maybe I will be the egg at a big rock party today because everybody is here to obviously cheer on and celebrate the Caribbean Court of Justice, which I will do. But I also want to take a critical look at the role of the court, especially when it comes to the view that the court creates a homogeneous Caribbean identity. And it's something that we need to question and we need to understand what the court is doing. So really the topic of my presentation, which I changed slightly, is whose stories decolonial constitutionalism and the Caribbean Court of Justice in Trinidad and Tobago. And today is a great opportunity to reflect on the word of the court and also what sets the background for today's discussion and we should bear it in mind, is a recent poll by Professor Hamid Ghani, published in The Guardian here in Trinidad, which shows across all demographics, age, gender, ethnicity, religion, majority of Trinidad and Tobagonians oppose joining the CCJ and wish to remain in the Judicial Committee of the Privy Council. Now, those stats are not alarming. They should not surprise anyone who has been tracking the debate here or across the Caribbean and across the various referendums that have been held in different countries. But let me say at the beginning that I think as scholars and part of the elite of our society, let us not dismiss that, we must accept the people's will and the people's will as part of our democracy to reject the Caribbean Court of Justice for varying reasons. And I think we have to start with that premise. Otherwise, this debate about whether Trinidad or Jamaica or any other country should join the Caribbean Court of Justice will not advance. Let me say that again. We have to accept that it is people's will, and we have to accept that it is the will of the people, if we proclaim that we are part of democracy, to reject the Caribbean Court of Justice. That's fine. Let's start there. Doesn't mean that you on a personal level rejects it, but you have to accept that's part of the debate. Now, and we do this because there's recent studies, none other by Rand Herschel, looking at the fact that process is sometimes just as important, if not more important, when we are talking about constitutional reform. And when we're talking about joining the Caribbean Court of Justice, joining the Caribbean Court of Justice is an act of constitutional reform. And they argue that participation can engender public support for a constitution, regardless to the extent of which the impact of that participation had on the actual text or what ends up in the Constitution. So the point is that people must be involved in a decision to join the CCJ or not. That does not mean that that decision has to be done through referendum. I will get to that point a little later. But the point that this modern research is showing is that public participation is important, even more so sometimes than the actual detail of what you will put into the reform. Because if the public they don't buy into it, you don't get the support that you need for that constitutional reform or for that output. Now, and what I will say is, and this is something that Professor Ghani said a couple years ago, he says the political and the intellectual elites are completely disconnected from electorates in various countries across the region on the matter of joining the Caribbean Court of Justice. Their biggest mistake is to get angry about the rejection of the Caribbean Court of Justice by Caribbean voters and not to try to understand the reasons as to why there is little trust and there is no consensus on making the change. Now, that means that symposia like this are important, and therefore we should congratulate the law school, we should congratulate the dean on being able to bring the minds of the Caribbean to focus on the question of why aren't voters in the Caribbean buying into the Caribbean Court of Justice in Trinidad and in other countries like Jamaica. Now, I think part of the problem, and this is my other background, my other hat as a political, with a background in politics, is that framing the rejection of the Caribbean Court of Justice in terms that the people are backward, they don't know what they're doing, tricked by wicked oppositions, call into question the patriotism or the commitment about regional integration will not advance the Caribbean Court of Justice. And obviously, Trinidad, 20 years later, proves that point. It will not change the merits or the demerits about whether Trinidad joins the Caribbean Court of Justice. The reality is that people all over the world are questioning whether liberal democracies, part of their independence projects, are questioning whether the decolonial project that we are here celebrating delivers services. Does it deliver on the ground? Does it improve their lives? Has independence offered the people of the Caribbean the hope and the dreams that were so brilliantly expressed in Woodford Square, in Independence Square in Barbados, all across the region. And that is something that we as intellectuals must contend with to understand, is the independence project being called into question, and is the independence project of the region failing our people as a region, and therefore what is the story of the Caribbean Court of Justice in that project, and how can it help with the renewal of the independence project? Now, the Caribbean Court of Justice Privy Council debate has railed on. I'm not going to get into it. We've already had the two sides, the critics of the CCJ and supporters of the Privy Council will argue they have no confidence in the CCJ making laws. You know, these people out here in Trinidad, they're making laws for we. Who are them? Then on the other side of the story, you get the critics of the Privy Council, and the supporters of CCJ will argue that the CCJ is independent by design. Why are you questioning this court? It has delivered excellent judgments for 20 years. We should be proud of it. This is a great regional institution. Better than cricket. Anything's better than cricket now. And the usual argument is that the CCJ represents this break with colonial history and traditions. All true. However, what these debates have done is that they're what I call nested oppositions. I'm not the first person to come up with this term, in that the debates are feeding on each other, and in doing so, they're talking past each other. So we've had 20 years of conversations with some on this side and some on this side. There's been never any compromise in the end, in the middle. And the reality is that in some ways, maybe the universe of these two debates, what we can call nomos, Robert Cover talks about it, they cannot understand each other. They will continue to talk past each other. So how do we actually break the backs of this debate? We've got 20 years of evidence that it ain't working. What we're doing right now is not working. Jamaica isn't budged, Trinidad ain't budging, the others ain't budging. What are we going to do? Are we going to spend another 20 years, by which time Professor Balantuan will definitely be tired, talking about this? So how do we move this forward? And I want to start with a very simple, basic proposition. And perhaps maybe because I teach law and legal systems, and those who teach law and legal systems, and Professor Balantuan will probably appreciate the point as maybe what we can call the godmother of law and legal systems in the I say exactly. In the Caribbean, is that it's a very prosaic proposition, but courts make laws. Judges make laws. That's what they do. And it's obviously still alive and an important discussion because Justice Witt in Joseph and Boyce made the point. He had to make this distinction because obviously it came up that there's a difference between making laws and making law, and he says, although laws is the plural of law, the latter, law, nevertheless conveys a wider meaning than the former laws. Making laws is merely one form of lawmaking. So the judiciary makes laws, the executive makes laws, the legislature makes laws. Obviously, legislation is given power to the Constitution. All of our Caribbean constitutions speak to this. The legislature shall make laws for the good governance and peace of our Constitution. We know this by heart. Now, just a little segue. We have Hart talks about judicial discretion, Philin Lucana. Darkwing talks about laws being ambiguous, so he came up with principles. John Austin, really the founder and father of Protestantism, jurisprudence, says that declaratory theory was a childish fiction, and that was in 1873. So the reality is nobody can deny modern contract, tort, equity, all of these things, judges make laws. Fast forward, Lord Gough in Woolwich makes the point that he's not sure where to draw the boundary between judge-made law, legislative-made law. So we accept that. Therefore, if judicial lawmaking is true in common law, the same can be said of constitutional law, of Caribbean constitutional law, which is a mix of judicial lawmaking by the Judicial Committee of the Privy Council, and the Caribbean Court of Justice because we have two apex courts running side by side. And sometimes in that debate, that gets lost, that really what we have is a growing mixed jurisprudence, whether we like it or not, in the Caribbean of two courts, two different universes, two different languages speaking sometimes past each other, across each other, but they're defending their territory. The reality is the CCJ can only understand what the CCJ does. The Privy Council can only understand what the Privy Council does. How else? Because that is their language. You create a language, you create words, you create terms to understand the universe around you and to reach out. Now, I want to illustrate something here. I'm not going to go through them. Just a few cases in terms of the CCJ to say McEwen, we've had Neves, we've had Joseph, we've had Bisram recently, and all of these cases speak to a repudiation of savings law clauses. We all applaud that across the region. We teach it in our first year, teach it in our second year. We talked about how these savings law clauses will shield independence colonial laws from views in favor of the human rights clause in the Independence Constitution. And recently, Marin, the CCJ said something very interesting. It says, Constitution that they're attempting to create a Constitution rights-centrist focus. Let me say that, rights-centrist focus, anchored in Caribbean identities. And at that moment when they said Caribbean identities, I smiled and I stepped back a little bit because my question, and they go on to say, and it's facilitative of access of the courts for effective interpretation, application of the Caribbean constitutional principles, values, and principles. Now, my question is, and this is something that we perhaps in this room and outside of this room will have to face up, that requires further discussion, and especially for those who support the court, what are these Caribbean identities the Caribbean Court of Justice is creating? How does the court, this goes back to my first proposition, hold them apart? And someone here mentioned it, hold these individual Caribbean identities, because I'm Barbadian, I'm not Trinidadian, separate. However, when we get together, we're definitely West Indian, and we're definitely from the Caribbean. Sometimes you got another mix in there, so you might be Vinci, or you're Aleutian. Who knows how far do things mix up, or is Guyanese part. So how does the court hold all of these multiple identities that we inhibit and that we carry within ourselves? And we should ask, should this be up to the Caribbean Court of Justice or any apex court in trying to frame or speak to the Caribbean identity? And that's a serious question. It is something that we take for granted because most of the time we talk about the court, we assume that we've all bought into the role of the court in shaping what the Caribbean person should look like, and we all have a view and we all agree what that Caribbean person is, but that is not so. Otherwise, we wouldn't have democracy. Elections won't make any sense because we vote for different people, we vote for different parties, we support different policies. We all carry different moral propositions and values. Because when we are born into this world, we don't come empty. We come because we stand from something. We stand from a place. And those places sometimes will conflict. That's normal. Now, those are the CCJ cases I just mentioned. Rights, privilege and rights, promotion of this new Caribbean identities. Then you have, on the other hand, Privy Council, Chandler, acknowledges CCJ judgments, but relies on precedent, will not depart from its precedent, which effectively saved the colonial laws. But the Privy Council did something that I thought was interesting, maybe overlooked. It said, you know what, it's up to the Parliament of Trinidad. If they want to change the law, they can change the law because in their view, that is not the role of the court. The CCJ took a different opinion because its mission, its universe, tells it the role of the court is what? Decolonization. So why are we surprised that the Privy Council will do different? Why are we enraged? It can't do any different because the mission of the Privy Council is English constitutional jurisprudence. The mission of the CCJ is Caribbean decolonial jurisprudence. They're very different. However, there may be something to the fact that we have to acknowledge that we in the Caribbean, because of poor political systems and the Westminster, have handed over lawmaking to the courts. Because the politicians aren't getting it right and don't want to get it right, or maybe can't get it right, it then ends up in a court. So when a case comes before the CCJ, but they can't just hold up their hands and say, well, I can't do nothing, they send it back to the parliament. Because there will be equal outrage if they did that. The case goes before the Privy Council, they do have the convenience and they do have the privilege of saying, I can't do anything, send it back to the parliament. Because they're not here and it's not their mission. It's not the mission that they established for themselves anyway. So, whose stories are being told? When we see the judgments from the Caribbean Court of Justice, we see the judgments from the Privy Council, a judgment will privilege and deprivilege aspects of the law. It will include people, it will exclude people. This is what the law does. Any apex court is not only making laws, and I'm going to go to the title of my paper, they are telling stories and trying to craft identities about a nation. They're trying to create personhood. They're trying to make us into people, whatever that view of their humanity is, that we're supposed to be these just, upright, moral, outstanding citizens of the world. What does UE say? We're local, national, regional citizens or global citizens anchored in regional traditions. Wittgenstein perhaps said it best. He says, to imagine a language means to imagine a form of life. So when a community, we speak through a language, the question is, what sort of community are the different apex courts in the region building? So instead of asking a question about the merits or the demerits of the Caribbean Court of Justice or the Judicial Privy Council, using the usual comparators that we all know, why don't we just change the question? Why don't we ask, what stories does the Caribbean Court of Justice tell? What stories does the Privy Council tell? And then the follow-up, are those the stories of the Caribbean people that you, Trinidad and Tobago, want told, or me in Barbados, or St. Lucia, Guyana, or wherever you are, Dominica, Grenada, Belize, are those the stories that you want told? So if we get back to the cases, Boyce, McEwen, Neves, Chandler, the question is, how does Trinidad and Tobago want to define ideas and concepts about rights and justice? Go back to Robert Cover, we talked about in worlds and nomoses and the fact that judges are telling stories. So when the JPC tells the Chandler story, it could only do so from its nomos. When the CCJ tells the McEwen, Neves, Bisram story, because they're stories. They're judgments, but they're stories because they're crafting views about how we see ourselves, how we operate in the world, and what we think about justice. It can only do so from its nomos. So we shouldn't be surprised. Now, I want to end really with the fact that Parliament in Trinidad has to make a decision of what it's going to do. If Parliament accepts that through independence, through republicanism, that there's a decolonial mission and decolonial principles in Trinidad, then rejecting the CCJ will contradict those decolonial principles. So it has to decide what it's going to do. Yes, you can do the two-thirds majority vote, but you probably should have constituent assemblies to try to move this forward. And I want to end by saying and making reference to Trinidadian writer and essayist Earl Lovelace, and seminal novel, The Dragon Cannot Dance. Lovelace critiques Trinidad. He talks about the litany of half-filled promises, partial successes, about national independence, but he does something interesting. He talks about the cultural survival because he turns to the people of Trinidad, who he describes as taller than cathedrals, more beautiful than avenues with trees. But he's not uncritical of the illusion of the homogeneous of the people. This is why I go back to the identities. In the carnival theme of All of Is One, when the divisions drift away, but what happens after Carnival is over. So whose story is the Caribbean Court of Justice trying to tell? Importantly, whose story does the Caribbean Court of Justice not tell? Because often in celebrating the CCJ, we look at the stories, the inclusiveness, but in including, you always exclude. That's just a part of it. And if you really want to have an inclusive agenda, you have to figure out who stories are you not telling? And does the debate between the CCJ and the Privy Council shield the CCJ from the type of critique that is required? And can the CCJ tell the stories of a struggle against neocolonialism to create individual and collective identities that bind a plurality of interests, that we call nations, then we call them a Caribbean, that give meaning beyond the 2 days of the carnival, all of we is one. So all of we actually become one without, and this is a task, I don't know how they can do it, without losing our individual identities as people, as communities. Lovelace does not leave us without an answer, as any good novelist and writer does. And he says in Growing in the Dark, the future is still to be won. Thank you.
Thank you very much, Dr. Yearwood, for planting our feet firmly on the ground and the realities of the situation that we find ourselves. I really like your take on this whole issue of Caribbean identity, because as you said, when we're outside the region, then yes, all of a sudden we are West Indian. Inside the region, though, it's Trinidad Carnival versus crop over, all these little debates like to spring up, right? But that is the reality that we have to face if we're trying to say that there's somewhat of a Caribbean identity and we're giving a court a huge mandate in that sense. So moving on to our last speaker for this panel, Mr. Jagru will be speaking on Developing Regional Jurisprudence, the CCJ debate.
Good afternoon, distinguished guests. My name is Jared Jagru. I'm an attorney at law. And you will forgive me if I am not as eloquent as the learned chairman or Dr. Yearwood. I am but a humble young attorney practicing here in Trinidad and Tobago. And I'm here to give you some of the views from the practitioner's point of view. I'd also like to bring greetings from the Assembly of Southern Lawyers, and I'd like to thank the UE for inviting us to take part in today. Now, the CCJ represents a significant step in the development of regional institutions in the Commonwealth Caribbean. Of that, there is no dispute. But the CCJ is not necessarily the first of its kind. The concept of a regional court to service the entire Caribbean or large parts of it dates back to over, I think, 170 years. If we go back to 1859, when a common court of appeal for the British Windward Islands was established. And since then, it has reincarnated in different forms, different fashions, names, with different territories being a part of it. In 2001, the agreement establishing the CCJ was signed by 10 member states. And the following countries replaced the JCPC with the CCJ as their final court of appeal. That was Barbados, Belize, Dominica, and Guyana, and I think now St. Lucia as well. So when one considers that this concept of one court to rule them all has been in existence for several decades, we have to take a step back and ask ourselves, well, why is the CCJ as an apex court so hard to accept? As we established earlier, the CCJ has two jurisdictions, the original and the appellate, and I will focus more on the appellate jurisdiction. As of today, as I said, Barbados, Guyana, Belize, St. Lucia, and Dominica use the CCJ as their final appellate court, while several other jurisdictions, Trinidad included, maintain the JCPC. So one of the issues that continuously arises is, well, we as Caribbean people would like to have our own people adjudicating in our final appellate court. And recently we saw that the JCPC actually invited one of our local eminent jurists, Chief Justice Pereira, to sit with them. I don't think she's the first, and I definitely don't believe she'll be the last. But coming back to the CCJ, we also invite non-Caribbean judges to sit with us. So we have had Justice Witt from the Netherlands Antilles, Justice Hayton from the UK, and most recently, Justice, you'll forgive me if I with the name, but Eva Osiji from Nigeria. So it's not necessarily that we are adverse to having a non-Caribbean influence in our court, it seems. We also talk about, well, we would like to have regional jurisprudence developed that maintain or promote a regional Caribbean culture and identity. But if you look at many of the JCPC judgments, they don't shy away from Caribbean culture or identity. From as far back as Maharaja and the Attorney General in No. 2 in 1979, the JCPC recognized the unique constitutional guarantees under Trinidad's constitution and gave weight to local judicial contexts in assessing fair trial rights. More recently, in Maharaja and Petrochin, which is a 2019 judgment, it was about a case for the leave for judicial review. The JCPC cited with approval the learning of our own High Court judge, Justice Rampasad, in another unrelated judgment that he had given in the High Court in Maharaja and the Port Authority. So the JCP shows judicial respect for local precedent and legal culture. So we ask ourselves, why does this matter? It shows that both the CCJ and the JCPC value diversity and balance between local and international legal perspectives. So when you look at it like that, the notion that only a regional court can appreciate our local circumstances doesn't seem to quite withstand scrutiny. Would that be the reason why we have so many failed referendums? One must ask itself. It doesn't seem to be the reason. And we went through the composition of the judges. JCPC invites regional judges to sit with them. CCJ invites non-Caribbean judges to sit with them. So we move on then to the argument of cost effectiveness and the need to promote access to justice. But in the grand scheme of things, how many cases from our local courts actually reach to the apex court? There is a push from the intellectual and academic section of society that, a local court allows local people to have greater access. But where's the data to really show that? Where's the data to show that post-acceptance of the CCJ, countries like St. Lucia, Dominica, Guyana, and Belize enjoy more appeals to the CCJ as opposed to what obtained before? Or conversely, where's the data to show that countries like Trinidad or Jamaica do not enjoy as many appeals as their CCJ counterparts. We also talk about the cost of going to the JCPC as compared to the CCJ. We talk about the filing fees, but a large bulk of the cost is actually related to legal fees for attorneys. And has anyone ever interrogated whether it's more costly to retain a UK counsel as opposed to a local counsel? Previously, before COVID, a large part of the cost to the litigant was the cost of traveling to the UK. But now with virtual and hybrid hearings, that doesn't seem to be so important anymore. So I was looking around and I stumbled across an article from Ms. Desiree Artizi, who's a barrister in the UK. And she specializes in Privy Council appeals. And in her article, she wrote, the JCPC now conducts quite a lot of its work remotely. Indeed, a casual browse of the JCP's website will allow you to watch recordings of the live hearings from Mauritius, for example, all taking place remotely. It has no longer been the case that London barristers are more expensive than a local QC. Barristers operating in the UK run small, self-employed enterprises. This means that they do not have the overheads that, say, a lawyer operating from a firm may have. That is what makes barristers competitive, and the reason why I suggest barristers will remain so. The flexibility of the JCPC can be demonstrated by the way in which the board has adapted to the changing cultural norms and mores of the Caribbean society. I would also suggest that the JCPC has been at the forefront of adjudicating on what would otherwise be seen as highly controversial social, political, and/or religious cases. And she quoted an example of a case, Isaac and the Attorney General, in which he acted in. Then she goes on to say, finally, it is not quite correct that the JCP has drawn on cases entirely from the UK when hearing Caribbean cases. Over the years, the board will draw on cases from across the wider Commonwealth, India, Australia, and Canada, or as necessary. This takes us back to the point I made at the beginning of this article. It is the breadth of territories and cases covered by the JCPC and the experience that their judges bring to bear that perhaps explains why Jamaica and Republic of Trinidad and Tobago continue to avail themselves of the appellate jurisdiction of the JCPC. So that last part there, to me, reveals that the idea of this indigenous apex court dispensing justice more in line with our own cultural norm doesn't seem to really get off the ground. The world is moving towards a universal concept of justice. So, and that can't be more evident than the fact that we have UK judges from the Netherlands, Antilles, and now from Nigeria sitting in the CCJ. So the arguments about cost effectiveness and greater access to justice, again, doesn't seem to withstand scrutiny. So there have been repeated calls for Trinidad to join the CCJ. It's coming from classrooms, lecture halls, political platforms. Years ago when I did Caribbean regional law in UE, it was the same cry. But we are ignoring the elephant in the room. Consider the Eastern Caribbean Supreme Court. That's a regional judiciary for 9 territories, and out of them, only 2 have the CCJ as their final apex court. It seems odd that several islands who in principle already share a common high court and a court of appeal have different final apex courts. One would think that it would be easy for them all to agree and say, hey, we should have one CCJ or vice versa. So there have been referendums, as Dr. touched on, in Antigua and Grenada in 2018, and the populations voted against the CCJ. In those referendums, the voter turnout itself was low, about 30%. So the first thing that tells you is what? That out of the 3, if you take 3 people in the population, only 1 voted. The 2 others either didn't know or didn't care about voting. And the one that did, 50% of those, well, more than 50% of those voted against the CCJ. So I asked myself, why? Why is the common man on the street against it? And I was looking around last night, and I think I stumbled upon the answer in an article from Dr. Wendy Grenade, who was then the head of department and senior lecturer in political science at the UWI in Cave Hill. And she quoted the president of the CCJ, Justice Saunders, as giving 2 reasons for the failed referendum. The first is this. Firstly, is the fact that people have unhappy experiences with their local justice system. If the court is held in a less than adequate courthouse, if the courtroom is stiflingly hot, if the case is adjourned again and again and again, if a murder accused spends 10 years on remand before his case is heard, then the idea of replacing a British institution with a Caribbean one is instinctively unappealing. And that was in 2018. We're in 2025. I personally had the experience and the privilege of going to the BVI to do a matter in 2019. And their High Court at the time actually doubles as their House of Representatives. And it was substantially smaller than what obtains here in Trinidad. And if you add in a battalion of lawyers and the members of the public who wanted to observe, it doesn't make it any more comfortable. And this is where the common man and woman and child goes to wait on justice. Earlier this year, I had the privilege of going to St. Lucia to do a High Court trial. And their civil High Court is now temporarily housed in a portion of a second floor on the waterfront where the cruise ships come in. So the common man now has to jostle between the cruise ship visitors in the busy capital, fit into this small courtroom, and go into the box, start giving evidence, and when the truck and the bus pass in, they have to stop because you can't hear anything. So 7 years later from the president's statements, we just seem to see more of the same thing. Recently, I was reading a judgment from the CCJ, Deorani Singh, where the court had to remark that, the judgment that they were adjudicating on, the written judgment only became available the day before the hearing. So, and we here in Trinidad have our own problems. When I came out into practice, it was not very long ago. The big burning issue was delay in completion of criminal trials. That seems to have spread over. We see correspondents complaining about the delays in the family court division. And as a practitioner of civil mainly, some of the same issues are creeping up there as well. And this is not here to point fingers or blame anyone. Of course, these can be addressed by allocating more resources and better management. But the point is, we need to get it right at the bottom first. We need to get the first port of call where the average citizen enters the court because he or she is in need of assistance right. We owe it to the common man who will not likely reach the JCPC or CCJ at the magistrate court level, at the high court level, because developing regional jurisprudence said, as Doc said, judges make law, they deliver judgments. So jurisprudence doesn't start at the apex court, it starts at the magistrate court, at the high court level. And putting the word Caribbean in front of the court is not going to solve those problems. It may seem to be an attractive academic discussion, but the focus needs to be starting with the delivery of modern, efficient, fair, and meaningful justice from a system that caters to the needs of the people. As my senior would say, justice in real life, not just on paper. If you look at the judiciary's annual reports, for 2020 to 2021, there were over 34,000 filings in the magistrate court, 668 petty civil matters, and almost 6,000 active matters filed in the civil high court for that period. At that point in time, over 40% of the criminal matters in the high court were over 10 years old. And for the same period, the CCJ had 4 new cases filed under its originating jurisdiction and 41 new under its appellate jurisdiction. So we see that the impact of the judicial decision is really at the lower level. And the judiciary, as we go up, it's almost like a pyramid. It narrows and tapers as we go up. So we need to stop focusing on the top so much and focus on delivering justice to the average citizen who sits in the magistrate court or the high court or even the Court of Appeal. Madam Justice Rajnath Lee said that they had made recent developments with the endorsement of modern criminal justice reform. So we need to be honest and sincere, because the man on the street doesn't object to the CCJ. He doesn't hate the idea of a regional apex court. But if they don't have confidence in our ability and maturity to deliver justice, we'll just continue to have failed referendums. But if we do the hard work, earn the trust of the people, they will happily accept a regional court, I believe. So the focus needs to be on addressing the issues faced by the common person and the administration of justice for real people with real issues. And as the learned principal said, we need a revolution. So if we are honest and sincere and focus our energies on ensuring that the local judicial system serves the people and show them that we can be trusted, then I believe they will in turn support a regional apex court. Thank you very much.
Thank you, Mr. Jagru, for reminding us what people really care about, the day-to-day justice system, and for how the perception of the low courts as well as the infrastructure bleed in to the feelings on the apex court. So I know I said we'd have questions at the end, but we've had a slight change in schedule. We're going to take a short 5-minute break now, and then we're going to proceed to our next panel, but you will have a chance at the end to ask those questions. So 5-minute break now. Thank you so much to all of our panelists.
I will do the same thing with the slides for Dr. Sure. I can just do it from sitting across the No problem. All right. So I'll come to you or you come to me?
So your presentation is next, right, Doctor?
Yeah, I think it's a short little break. I think on the program.
So I hate to break up the engaging conversations that we're all having, but can I invite everyone to take their seats as we resume? Okay, we can now take our seats, please. I do hate to be the one to break up your conversations, but we do need to proceed to the second panel.
Justice will change the slides for me.
Okay.
Right?
So I think
And I'm going to
just a gentle reminder, if everyone can please have their seats so that we can begin with the second panel discussion, please, ladies and gentlemen. And you can feel free to bring your coffee or tea to the table. All right, so I'm now going to invite our second moderator, Mrs. Adana Joseph Wallace, attorney at law and lecturer at the Faculty of Law at the UE St. Augustine campus, to begin our second panel discussion on perspectives on the CCJ and the JCPC. Ms. Wallace.
Good afternoon, everyone. Thank you for remaining with us. I will not delay because we know that we have to move speedily along in the interest of time, but I want to thank you for continuing to be with us, and I can assure you that we will continue to be as engaging and interesting as we have been so far. I am going to invite on stage our three panelists this afternoon, Mr. Frederick Chilks. Dr. Sophia Ali is already seated here, and Dr. Indira Rampasad, sorry. And without further ado, Mr. Chilks, don't sit. I am going to ask you to come one time. All right, so thank you.
Good afternoon, everyone. First of all, I wish to thank the faculty for inviting me to participate today, to bring a few remarks. I am not going to be getting into the CCJ Privy Council debate, because my presentation is focusing on recent developments regarding conditional leave to appeal to the Judicial Committee of the Privy Council and what has been happening in our Court of Appeal. And I know we have constraints of time, so I'll dive right in, and I promise to be short. Although, yes, my colleagues at the Law Association are saying, oh, yeah, right. But I do promise to be short. Now, Trinidad and Tobago's constitution makes provision for appeals to the Judicial Committee as of right. Of course, there are circumstances in which you would have to get leave, special leave, and that sort of thing. But under Section 109(1) of the Constitution, a litigant may appeal as of right any final decision in civil proceedings where the matter in dispute on the appeal is of a value of $1,500 or upwards, or where the appeal involves directly or indirectly a claim to or a question respecting property or a right of the value of $1,500 or upwards. Of course, you can also appeal final decisions and proceedings in dissolutions or nullity of marriage, and final decisions in any civil or criminal or other proceeding which involves a question as to the interpretation of the Constitution and, of course, fundamental rights and that sort of thing. Now, traditionally, when there is an appeal as of right, all that was needed was really to satisfy the court of appeal, because you are making an application to the court. Despite the fact that you have an appeal as of right, there is still the application for conditional leave. And I have always understood an application for conditional leave as one in which you deal with the conditions that are prescribed in the Privy Council Rules 1962. So you provide for security, that sort of thing. Now, of course, in the Allen Ford case against the Attorney General in 1997, the Privy Council did make the observation that an appeal as of right, by definition, means that the Court of Appeal has no discretion to exercise, but goes on to say, all that is required, but this is required, is that the proposed appeal raises a genuinely disputable issue in the prescribed category of case. And in this particular case, it was a claim under Section 14 of the Constitution in respect of an alleged breach of the constitutional rights of the appellant. Now, of course, anybody familiar with the Allen Ford case would know that the appellant, his vehicle had been towed, and when he sought to retrieve it, he was denied compensation. As he was told, I have to pay to get it released, even though it was wrongly towed. And he suggested that that arrangement constituted a breach of his fundamental rights. And what it seems to me was the observation being made by the Judicial Committee on that occasion, is that you need to make sure, as a Court of Appeal, even though it's an appeal as of right, please make sure that this is actually a constitutional claim about a contravention of your fundamental rights. So don't just send the thing up the road. And with that, I mean, it's very difficult to say that you disagree with that. Now, of course, since then, the Privy Council, but not since then, but even before then, in Davy and Roy, in the 1940s, the Privy Council had said, when we are very reluctant to interfere with consecutive findings of fact. And what we will do is, we will entertain the appeal, because if you're appealing as of right, but when you come, you must start by satisfying us that there are exceptional circumstances. On the face of that, it seems that the Privy Council has said, you know, we will entertain the appeal, but we are telling you that you're going to have to satisfy us on a very high standard, that the two courts, the two levels in the courts below got this wrong. Now, one of the things that Davy and Roy set out as a criterion is that if you are talking about consecutive findings of fact, you are entitled to come and say the decisions in both levels of the court below were against the weight of the evidence, and that is regarded as a point of law. And even in the industrial court, when they say you can appeal on a question of law alone, the Court of Appeal tends to entertain the appeal if it's so against the weight of the evidence that it must be that there's some error of law. So this is not an unknown proposition when talking about hearing an appeal where there are consecutive findings or concurrent findings of fact in the courts below. Now, what has developed recently based on a decision delivered by a couple decisions delivered by the Privy Council in the late 2010s, one of them is hailing from Antigua and Barbuda in Maya and Baines is the suggestion that the Court of Appeal in the particular jurisdiction is entitled to do some sort of sifting exercise or weighing exercise, even when you are appealing as of right. And in this particular case, the claimant had obtained a judgment in default against the defendant. The defendant sought to have the judgment set aside. It was set aside by the master. The Court of Appeal disagreed with the master's finding that there were exceptional circumstances and said that the judgment was properly taken up and it should not be set aside. The disgruntled defendant sought to appeal to the Judicial Committee of the Privy Council and as a right, and he was refused. So he made his application to the Judicial Committee directly. They granted leave, agreed with the Court of Appeal that they had correctly decided the decision, but went on to say this. So Mr. Meyer thereupon applied to the Court of Appeal for leave to appeal to the board pursuant to Section 122(1) of the Constitutional Order. He contended that the Court of Appeal had given a final decision and that under the terms of the Constitutional Order, he was entitled to appeal as of right. The Court of Appeal disagreed and refused this application. So on the 30th of May 2016, Mr. Meyer made an application to the board for permission to appeal. That application was successful, and on the 13th of December 2017, Mr. Meyer was granted the permission he sought. Now, the board considers that, this is later on in the judgment, that this reasoning is also applicable. They've talked about the reasoning of the Court of Appeal and why they agree with the Court of Appeal. The board considers that this reasoning is also applicable to appeals where the Court of Appeal of the Eastern Caribbean Supreme Court, Antigua and Barbuda in this case, Mr. Meyer, they agree with the Court of Appeal's decision, and Mr. Meyer made an entirely proper application to the Court of Appeal by notice of motion for leave to appeal. But the Court of Appeal has a right to police applications of this kind and to consider whether any proposed appeal raises a genuinely disputable case. And then they go on to cite the decision in Allen Fort. Except that, what appeared to arise for the determination by the Court of Appeal were questions of law, fact and law, in terms of whether or not you satisfy the criteria for exceptional circumstances setting aside the judgment. And it's not easy to understand why the Court of Appeal could feel that it could refuse to grant leave to appeal when the appeal is as of right. Or why the Privy Council was suggesting, well, look, they're referring to what is a genuinely disputable case. But surely, first of all, they entertained the appeal when the application was made, only to agree with the Court of Appeal. But in their view, obviously, there was a genuinely disputable case within the category. So the question really arises as well, what are you saying to courts of appeal in the region is the meaning of what is genuinely disputable? Now, the issue arose in Trinidad and Tobago Court of Appeal in a case of Sherian Rajkumar and Southern Medical. And in that case, reference was made to the Allen Fort case. Yes, reference was made to the Allen Fort case and also to the Meyer and Baines case. And Mr. Justice Kokram said, well, look, the Privy Council agreed that the Court of Appeal has an inherent power in exceptional circumstances to refuse leave to prevent an abuse of the process of the court, of the appellate process. But the facts of the Sherian Rajkumar case were such that it seemed to me that the Court of Appeal could properly say that this was not a genuinely disputable case falling within any category that allowed of cases which allowed for an appeal to the Judicial Committee of the Privy Council. But I think His Lordship, Mr. Justice Kokram, was making a nod to the fact that there is this authority coming out of the Judicial Committee which suggests that there is some sort of exercise that the court is supposed to conduct inherently in exceptional circumstances. It doesn't say what the exceptional circumstances are. What has developed since then is that the Court of Appeal is refusing conditional leave to appeal in cases where there are concurrent findings of fact. And even though Davy and Roy, the Privy Council, sets out the test, he said, look, if we will tell you at the very beginning that you must meet this high standard, so you must come and deal with that at the outset. This is this high standard you're going to have, but they will deal with it. And this is the approach that has been taken by the Eastern Caribbean Court of Appeal previously in the case of Martin and Peters, where the argument was made that these are concurrent findings of fact, and the Privy Council is not likely to entertain it, and His Lordship, Mr. Justice Rollins, said, well, this is a matter for the Judicial Committee. It is not for courts of appeal to decide that these are concurrent findings of fact. Because especially when the question that arises is, well, are these findings against the weight of the evidence? Well, then how are you going to say, well, I made this finding, I think the finding is consistent with the evidence, but I don't think that the Privy Council will disagree with me. So I am saying that, that they will not agree, and therefore I'm denying leave. Particularly, as in one recent case, the question that arose was not only whether the findings of fact could be sustained, but whether those findings were sufficient to satisfy the requirements of fraud. So it's a mixed question of fact and law. And you have the Court of Appeal refusing leave on the basis that, well, we do not believe that this is an argument that is going to prevail at the Judicial Committee. Now, of course, the option is still available to the litigant to go directly to the Judicial Committee. But it would seem to me that it is an uncomfortable development to have courts of appeal where the appeal is as of right, reading into the Constitution, which seems to be very clear and which was clearly applied for many, many years. I have been involved in matters in which there were concurrent findings of fact, and the Court of Appeal, and a party sought to appeal, and the Court of Appeal simply said, look, it's questions of fact, questions of law, it's as of right, you go into the Privy Council. That is not what is taking place now. And it's concerning because it would seem to me that, we are talking about the development of our Caribbean jurisprudence, but as previous speakers have said, the confidence must start with the person when we are exposed to our local courts, that people feel we can manage these things in a certain way. I would commend to, and this is not necessarily a plug for the CCJ, but I would commend to the Court of Appeal, which did consider this authority in its previous deliberations and departed from it. The approach taken by the CCJ in LOP Investments and Demerara Bank Limited, where his Lordship, the Honorable Mr. Justice de la Bastille said, with regard to this is a Guyanese case, with regard to the category of case with which we are concerned here, and it was a case involving exercise of rights under debenture, and the question whether those rights had been properly exercised, and the Court of Appeal said, well, we see no merit in the appeal. They reversed the High Court, and said, well, we see no merits in an appeal. Mr. Justice de la Bastille said, with regard to the category of case with which we are concerned here, that is, that prescribed by Section 6A of the CCJ Act, we have no hesitation in holding that once the proceedings are civil in nature and the matter in dispute is of the value of the prescribed amount, or the appeal involves a claim or a question respecting property or a right of equivalent value, leave to appeal must be granted. It would seem to me, I say so respectfully, that the Constitution is quite clear. And if we are going to talk about, confidence in our courts, it would seem to me that we must have the confidence to defend what plain words of the Constitution says, even if our apex court is suggesting otherwise, let them overrule you. But it would seem to me that we must start here defending the Constitution and what it plainly says. Those are my contributions.
All right. Okay, so thank you to Mr. Gilks. And your thesis, of course, made note of the important concern of access to justice, which was, it's not new today, as previous speakers would have mentioned, though not necessarily in the same way that Mr. Gilks just did, as it relates to leave as of right. I will now invite my colleague, Dr. Sophia Ali, to make her presentation, Beyond the Government, the Caribbean Court of Justice, and Private Actors. So please welcome Dr. Ali.
No, All right. Good afternoon, everyone. I should start by saying and confess to my bias. I am pro the CCJ in all its forms. So obviously that is what I will be arguing as we celebrate or commemorate 20 years of the Caribbean Court of Justice. I always remember I joined the Caribbean community just a few months after the official inauguration of the court. So I was extremely naive at that point, and I joined the CARICOM Secretariat thinking, oh, we have a treaty court, we shall go to court. No. That notwithstanding, the court has developed jurisprudence in the original jurisdiction, even though it took some time to start. And what I've always found interesting is that this jurisdiction, this litigation was initiated by private actors. And I say it says something about the progress of our regionalism and integration that this is, in fact, by that private actors. Because we all know the phrase when we talk about the Caribbean community, association of sovereign states where sovereignty is held paramount. Dr. Kavru talked about the elements of supranationalism. And it's interesting that litigation and challenging and interpreting the obligations of states have come by claims filed by private actors. So this is what I'm just focusing my brief presentation on, because I think sometimes it is overlooked how the CCJ has actually interpreted the treaty for the benefit or in respect of private entities, whether they are corporate or natural persons. And after 20 years, all of the jurisprudence of the court really should be considered when we make decisions, when we advocate for one position or another. So although I speak to the original jurisdiction, as previous speakers have said, both the appellate and the original jurisdiction are tied to integration. They are also tied to ideas of independence. And also, as I was listening to Dr. Yearwood, where the feeling about the court being imposed by political elites, that also is a feature of the history of CARICOM integration, and which is why I also think it's important to look at just what impact private actors have had in this jurisprudence. So the treaty, of course, provides for non-state actors to access the CCJ in relation to the treaty. And as I said before, since 2008, almost all the cases in the original jurisdiction have actually been initiated by private entities. The exceptions being, I think it was in 2018, a request for an advisory opinion from the community finally, and in 2020 when Belize filed an action. Those are really the only exceptions. So we have seen litigation of this access by non-state actors throughout the original jurisdiction. Some writers have called this a weakness, because if states aren't going to court, perhaps that reflects that states aren't really committed to a rules-based dispute settlement mechanism. But it could actually be a strength of reorienting regionalism or the actors within our community being given a voice. And so my suggestion here is, does this history of the original jurisdiction provide an incentive for non-state actors to maybe take a different role in advocating for the appellate jurisdiction as well, or something we should consider for those of us who admit our bias and say we're promoting it? Do we consider this? So if we define non-state actors, the general understanding is any actor that is not the state. International law recognizes non-state actors. It's a broad category. It could be natural persons, corporate entities, non-governmental organizations, international organizations as well. The treaty also has some specific recognition of non-state actors as beneficiaries of development. They're part of the goals of development in terms of business people, producers, etc. You have consumer protection built into the treaty, and they have specific rights. So in the context of CCJ litigation, the non-state actors are specifically the private individuals or organizations which have the right of access to the court pursuant to the treaty. So I'm going to be looking at private entities, essentially corporate or natural persons. So I will go very quickly through this because many of us may know this already. The procedure for access to jurisdiction by private entities is set out in the treaty. Unlike states and the community, private entities do not have an automatic right of access. So they do have to go through this process to prove. So they apply officially for special leave, and there are conditions that they must meet. There must be a person, natural and/or juridical of a contracting party, that was the wording, confirmed by treaty of right and/or benefit and establishing prejudice in enjoyment of that right. The contracting party who would be otherwise entitled to bring the claim has declined or omitted, and it's the interest of justice to pursue this. So I'm just going to go through these things briefly just to show what I think are really important and how the CCJ has interpreted the access by private entities. In that first TCL case, TCL against Guyana, Guyana had argued in the case of the company incorporated in Guyana, that was TCL Guyana Incorporated, that it was not intended by the framers of the revised treaty that a private entity should be able to sue the member state to which it belongs before the CCJ, and rather that such matters should be dealt with nationally. However, the CCJ considered this was a very restrictive interpretation that would frustrate the achievement of the goals of a revised treaty, because any state who was not complying with their obligations could simply say, well, it's the national who's affected, they will deal with it internally. In TCL and CARICOM as well, which was just subsequently, the community also sought to object to access by the private entity, to bring proceedings challenging decisions of the community body and Secretary General. The court rejected those restrictions on the right of access. It found that private entities must be able to challenge member states, even their own member states. Private entities play a major role in fulfilling the object and goals of the treaty, in particular the CSME. And they found that it was clearly the intention of the treaty that they should have conferred upon them and entitled to enjoy rights capable of being enforced directly on the international plane. And similarly, the ability of a private party to challenge decisions of CARICOM is a manifestation of that rules-based system created by the treaty. Then we come to espousal of the claim by member states. You have to remember, in the early cases that were brought in the original jurisdiction, every aspect was argued by the community or the member state. They were challenged on each of these points at special leave applications. So even in the case of espousal of a claim by a community, you would have had, for example, states arguing that they needed more time, that this case should not go forward because the contracting party had not responded, etc. And this is one where the court in its decisions have basically said that Article 211 gives to persons in accordance with Article 222 in their own right qualified access to the court. This has shaped how the court has considered the access of private actors to the original jurisdiction. And they have basically said, if you've written to your state asking for them to espouse a claim on your behalf before the court, and you get no response, or you get whatever response you get, as long as you've initiated that, the court will accept with a bare minimum of time that the member state has omitted to decline or declined to espouse the case. And this is an element of that special leave condition that is rarely argued anymore, I believe. We don't have, the pleadings aren't necessarily public, but if you look at the judgments, for example, in Rhodesa Beverages and Tomlinson, you can see where the court or the state makes passing reference to the procedure by which it came, and member states don't really use this as a block anymore. Another important thing is whether the rights or benefits of the treaty are limited to nationals. There was an issue with wording in the agreement establishing the CCJ, which was 1999, and the revised treaty, which was being applied in 2001, in force in 2006. And this is interesting because the court, in interpreting, the argument had been made in TCL and Guyana that the person who could access the court, person is the language used in the revised treaty, would have to be a national of a CARICOM member state. And this was really critical. Nationals of member states are defined in Chapter 3, which refer to specific Chapter 3 rights: movement of services, movement of nationals, the right of establishment, movement of capital, etc. But those are specific to nationals in that chapter. The court, in this case, was able to take a broader view of the treaty, looking at other elements of the trade regime, the common external tariff, etc. The common external tariff is intended to protect producers of community goods. There's no requirement that producers of community goods should only be nationals. What would that do to our investment policies or encouragement if only nationals could get the benefit of protection from the common external tariff if they were producing a wholly a good that met the community requirement? The language in that judgment I found very interesting, that the rights are to be derived or inferred from correlative obligations imposed upon the contracting parties. This again shows that the court was really looking at the intent of the treaty, not just in the interests of member states, but what it is these parties to the treaty had created. And they had created a treaty with thought, even if they didn't think of the litigation, but they created it for the benefit of economic activity and development within the region. And therefore, it was not only explicit rights that could be inferred from the treaty and enforced before the Caribbean Court of Justice, but if there was an obligation, like in this case, on member states to impose a common external tariff for the benefit of regional producers, then that creates a responding right for those producers. And I find this sort of, the CCJ said the obligation of member states to maintain a CET in respect of certain goods was of potential benefit to all legal or natural persons carrying on business in the community having anything to do with such goods. So So what you can see if you look at the progression of cases, the objections or the special leave applications that now come before the court, they don't rest on these procedural matters anymore. These are well settled. They primarily focus on the legal issue of a right or benefit in the treaty. That is where the debates have been focused. And we see in the judgments, for example, in Register Beverages, the court noted Guyana made no objection to the special leave application, either in terms of jurisdiction or locus standi of the application, etc. So it really has been a great progression from what was envisaged in just drafting that special leave to not focusing as much on these procedural elements, which are easily satisfied, but focusing on a right or benefit of these private entities in the treaty. This does not mean that the special leave is automatic. They just are debating a substantive issue. So it's a rights-based discussion rather than procedural. And as I can see from those, the Cabral Douglas against Dominica, Rockhard against Trinidad and Tobago from 2017, there are cases that are not able to progress beyond the special leave because they may not have been considered a right that inures directly, as in the case of Cabral Douglas. He was an event promoter in Dominica, and so he was not moving to provide services, so they did not, the right that he brought was not attached to him. I also think the CCJ has played a role in facilitating private litigants, and this speaks to what a lot of speakers have spoken about in terms of access to justice, and where is perhaps the data or how that has been. Well, certainly in the original jurisdiction, you can see that there's been this facilitative rule. You can see that, and I get people asking me, maybe non-lawyers, why do you focus on where they allow cases to go beyond special leave, or they don't, even if the litigant is unsuccessful, they're not made to pay the costs, because this is in the interest of developing justice and jurisprudence. And this always sticks with me because in Hummingbird Rice Mills, the Secretariat was able to successfully defend the community, but we didn't get our costs because we were the community. It sticks with me sometimes. But I can see the good in this, and at least for this, where the perception generally can be that this is such a state-driven jurisdiction, that integration is so top-down, that the court has ensured that private litigants can have access to the court, reasonable access to the court, and by them bringing cases to the court in the original jurisdiction, they're actually driving that development of jurisprudence. They become critical not just to the economic development, but the legal development as well for regional integration. So I'm not going to spend much longer. I had things, I will just show a snapshot where I tried identifying to be abated, where you can see that clearly cement is the most active sector. We have producers, and that might be a cost issue or a knowledge issue, because community good producers are more involved with the CARICOM mechanism than maybe smaller producers. But it's interesting to look at this spread, because of course the CCJ is limited by the cases that are brought before it. As Dr. Yearwood said, the court can only do what it knows it is doing. So the court can only make these decisions in respect of private actors or sectors that choose to litigate before it. So there are going to be limitations, which is why I happily promote for UE. I'm happy to be able to teach Caribbean integration and train lawyers who can bring more cases for individuals and smaller companies that may also get a benefit. So what So what I'm saying, essentially, to wrap up, just 2 slides. although CARICOM and member states have been challenged in the court by private entities, the litigation, and the consequential changes, because there have been changes made to participation of private sector in CARICOM, et cetera, subsequent to these cases. And you can see from the language of the Conference of Heads of Decisions and in creating the CARICOM private sector organization that they're actually reflecting the wording of the judgments that talk about the need to involve private sector in consultations. Private sector is a key player in integration process with advantages to gain from the CCJ. And I am hopefully not as naive as I was 20 years ago. So I do understand that the interests of private sector differs between the original jurisdiction and the appellate jurisdiction. I would like to say, though, that we rely on all of these stories, as Dr. Yearwood said, when we make our cases or we consider the benefit of the judges. It is one court with two jurisdictions, but it's the same judges sitting. So you can learn as much from how the judges have dealt with the original jurisdiction and also the appellate jurisdiction. I also think we need it feeds for legal integration of a different level. Where if we really have what the dream was, where all of us went to the same final court, regardless of our individual national identities, we would all be contributing to the same regional jurisprudence, and there would be a nexus between the appellate and original that we saw, for example, in Tomlinson case, where the court was able to acknowledge that this same court sits as the final court for Belize, as well as this treaty court, and therefore it could make certain kinds of determinations in respect of Belize. Imagine if it was able to do that in respect of legislation and what's going on nationally for all of the CARICOM member states, all who participate in the single market. So that may be a dream, but I think it's something that we should always consider and maybe invite private actors and individuals into these discussions beyond just political and legal elites. So law is shaped by where it's made, we know that. It is shaped by who makes it. We know the influence of courts in making laws and interpreting laws, and I believe we should reclaim it. Thank you.
Thank you very much, Dr. Ali. And I take on board what you say that perhaps we need to invite the private sector, or private actors rather, to fora such as these, as they seem not to be as suspicious of the court as we were told laypersons, at least in the original jurisdiction. So I will now invite Dr. Indira Rampersad to present. And her topic is 20 years of jurisprudence, perceptions and misperceptions of the Caribbean Court of Justice. So please welcome Dr. Indira Rampersad.
Thank you, Chair. All protocols observed, Honorable Chief Justice. Well, I have to acknowledge my principal. She's my boss. She could chastise me after. And the Dean of the Faculty of Law, I want to say special thanks to the Dean and the faculty for inviting me, judges of the Caribbean Court of Justice, and welcome Judge Chile, my friend Justice Maureen Rajanath-Lee, other judges, ladies and gentlemen, colleagues. Good afternoon, and it's a pleasure to be here. So when you speak last, you wonder if everything you're going to say has been said before. So you have to look for things that wasn't said before to say, and that means sometimes you have to throw aside your script. So Dean, I was told 30 minutes originally, so I prepared 30 minutes jurisprudence, as you could see, 20 years of them. And now I realize I may just have to shelve it because I think we had people dealing with the jurisprudence effectively. But I want to get back to this debate. And Principal, I know you tell me you're tired, but the debate is not over. The debate is ongoing, and the debate is as intense as it can be. And we were in Malta at the Commonwealth Lawyers Association conference, and you heard what was going on. You yourself said we need to debate it. But it needs more than debate. So I'm not going to say I'm biased, but when Justice Kafur and I ended this book, the conclusion of the book called for the non-subscribing members to come forward and subscribe to the CCJ. But on further reflection, and I'm not going to admit bias. I would say I'm a friend of the court. I'm not going to admit bias. I'm an academic after all. But started to reflect because I have to do another book, and this book is going to be more controversial. Okay, so Hilary Beckles actually engaged the controversy in the preface of this book. I got him to do the preface. And he engaged the controversy. And I told myself that is where I'm going to start the next book. Because this debate is by no means, has by no means ended. It is actually intensifying. And it's intensifying because we still have a number of Caribbean countries that have not subscribed. And I like what Jared did. Jared tried to get to the root of the problem. And Jared was my classmates. We used to sit together at Hewwood in law school. And so we have to get to the root of the problem. If it is a problem, first of all, we have to identify whether it is a problem. And what are the reasons then for this reluctance to subscribe if it is a problem? Okay, so we will have to identify what is a problem and whether this is a problem. So I have some slides here on the history and evolution of the court, and just want to say that this idea of a regional court was first mooted in 1901, and they had a legislation for dispute resolution mechanism for the region can be traced back to the West Indies Court of Appeal Act of 1919. The issue of regional court was again raised at the government level in 1947. A federal Supreme Court actually merged with the West Indies Federation in 1958, Article 2 of the British Caribbean Federation Act 1956. So this is an ongoing story. This is not a new one, and it is still there. And so I want to touch on two things that I think wasn't dealt with effectively yet, or wasn't dealt with because I said I had to look for what was new. And one is why this reluctance. So just as if we can just go to that slide where we identify the perceptions and misperceptions, or the anti and pro sentiments, the CCJ, the perceptions or the misperceptions is the perception that the court is politicized, or that the judges engage in conversation at the cocktails, okay, at whatever forums, whether it's formal or informal, or behind the scenes, through the phone, I don't know, with the politicians. So that is a clear misperception. And the Privy Council, because of its distance, is seen as impartial because there is no potential for that kind of intimate interaction between the judges and the politicians. I'm saying politicians. So, ironically, we have had politicians actually criticizing the decisions of the court. And I'm going to just cite Belize Bank. We had Wilfred Erlington, Foreign Affairs Minister of Belize, saying that he would not encourage anyone to follow his country in replacing the Privy Council with the Caribbean Court of Justice as a final court of appeal, because he didn't like the decision. He was Attorney General in 2009. His government introduced a constitutional amendment to do just that, but along with his Prime Minister, Dean Barrow, and others, he was furious over a CCJ ruling delivered which ordered the Belize Bank to pay the equivalent of $45 million to Belize Bank, a commercial bank. And then we had Frondell Stewart, former Prime Minister of Barbados. He referred to the CCJ judges as politicians in robes. After the decision of Eddie Ventos and Shanique Myrie, okay, Eddie Ventos was 2018, Shanique Myrie was 2013, and those two judgments went against the state of Barbados. Frondell eventually lost the election, whether that statement had anything to do with that, but it was like a landslide victory for the opposition. Okay, so the issue now that I want to deal with is the judges and the perception and misperceptions of the judges and the composition of the bench. This is an elephant in the room because it has ethnic, gender, and class dimensions. Okay? Now, when you start to talk ethnic, they say you're racist. So you just have to open your mouth on something like that, on ethnic, and they say you're racist. So, you know, we academics just have to find the ways to do it in an academic way. But there has been concerns among certain sectors of the population about the composition of the judges. And Justice Saunders was cornered in the media about the presence of no Indian in the bench. And in 2018, I think Justice Jamada would have come on board, and there was an Indian in the bench. The argument is there are over 1 million Indo-Caribbean people in the region, and no Indian in the bench suggest that that group is not represented in the bench. Now, is the bench supposed to be representative? I will go there just now. Then there is the gender issue, that there was one female at a time. We had Judge Desiree Bernard, and then she left. Then we had Justice Maureen Rajnath Lee. She's still here, and now we have two female judges in the bench with Chantal Unawayu as the second female in the bench currently. So the gender issue has played out in the public arena and also in the academic arena. Justice, you might just want to show this slide there with the judges themselves. So I went digging into this thing, and I've said, okay, we're trying to get to the root of this problem, because I have to write about it, and I have to do it in an academic way as possible. And trying to understand whether these concerns are justified or not, and whether they should matter. So the Privy Council judges, interestingly, the last presentation I did, yeah, so the last presentation I did, there were just the Right Honorable Lady Rose, one female, and last night when I went, I said, let me just check this so I wouldn't be wrong. Double check. They change their judges quickly. They change their judges faster than we do. And now there's another Right Honorable Lady Simla. So they have two, and we have two females. So they have 12 judges, and we have 7 currently in the bench. Okay, so this is the profile of, this is what they look like, because that matters. Getting there, Principal, I'm getting there. So now, the Regional and Judicial Legal Services Commission appoint the judges. And those people hail from different organizations in the region. So we have the president of the court as the president of that commission. Currently, Justice Saunders, outgoing President Justice Saunders. It will be Justice Winston Anderson when he leaves. We have 2 persons nominated from the organization of the Commonwealth Caribbean Bar Association, 1 chairman from the Judicial Services Commission of a contracting party, and that's selected in rotation in the English alphabetical order for a period of 3 years. The chairman of a Public Service Commission of a contracting party, selected in rotation in the reverse English alphabetical order for a period of 3 years. 2 persons from civil society nominated jointly by the Secretary General of the Community and Director General of the OACS for a period of 3 years, following consultations with regional NGOs. 2 distinguished jurists nominated jointly by the Deans of the Faculty of Law of UWI, the Deans of the Faculty of Law of any contracting parties, and the Chairman of the Council of Legal Education. 2 persons nominated jointly by the Bar or Law Association with contracting party. So the President is appointed by CARICOM heads of government, but such appointment must be recommended for by the RJLSC. Now there are concerns also about the composition of the RJLSC and the ethnic composition. But we are seeing these people are drawn from various organizations, stipulated in the rules as to how they should be. Okay, so we dealt with this issue with the politicians, and we saw that the politicians themselves had been criticizing the court, and the court has been chastising some of these politicians, and particularly the courts have also been chastising lower courts for their delay. The CCJ has, I don't know, made about 20 cases on delay. We picked up, and we went until 2020. The thesis, which I helped Justice mentored, and the book was up to 2020. You want to pick up on those cases. But I spoke to a foreigner, and I said, let me see, I have a colleague who is a Canadian, and not involved in anything political or judicial in Trinidad. His international relations, doesn't do the kind of research I do. And I said, so what do you think about this Caribbean Court of Justice, and why you think people are reluctant? I just want to hear a perspective from outside, and totally independent. He said, well, the corruption index. He said the corruption index of these countries are so high And the perception of these small island developing states and the potential for corruption is so high that they feel that every single institution is corrupt. And because the CCJ is the apex court of the domestic system, the appellate jurisdiction is the apex court of the domestic system, they see it as part of the judiciary and therefore part of the corrupt system of these small island developing states. So that is one of the perceptions. Okay. Now, the diversity principle. So, Sir Dennis Byron did a brilliant paper in Boston in 2013. I believe Justice Gafoor had attended that conference. And Sir Dennis Byron recognized the problem, and this is a problem of Trinidad and Tobago, a problem of Trinidad and Tobago in particular, because with the other islands there are other problems, and I will go there, but it is a problem with Trinidad and Tobago. He said, let us take Trinidad and Tobago, for example. Their skin color and political affiliation have historically been understood to be so tightly intertwined with Indo-Trinidadians associated with UNC and Afro-Trinidadians with PNM, that a whole cascade of unchallenged predictions, assumptions and accusations about how someone will or won't act are often made simply on the basis of skin color. To be even more specific in this example, the absence of an Indo-Trinidadian judge, that was in 2013, he was saying, because we said Justice Jamara came in 2018, on the CCJ bench has led to a host of concerns published in Trinidad's newspaper as to the ability of the court to render impartial, apolitical, independent decisions. Right? So he said, I acknowledge that the Trinidadian political racial stereotype has been shifting in recent years, but to some extent, the words that were uttered continue to color perceptions today, and it is likely that such perceptions and conflations of diversity and merit affect the politicians and the public's faith and confidence in the court. So he recognized that. And this is just one example of one stereotype in one country. But he went on to say, is that, and he cited Tracy Robinson, who said there is real value to the principle of representation. In her words, it is fundamentally a matter of justice because it signifies an equal right to participation in public life. Moreover, it can engender pride, confidence, and trust amongst the public. And we have another author, Kate Mallison, who's written a lot about the CCJ as well. She said, once a cycle of public mistrust has developed, even a court with impeccable institutional arrangements may struggle to build public confidence. Conversely, once public confidence in the independence of a court is embedded, its judges are able to draw on a relatively deep well of support, irrespective of the institutional arrangements or indeed the popularity of their decisions. And so Dennis concluded that what this suggests to me is that not only is diversity on the bench an important consideration because it can lead to public confidence, but perhaps diversity should be a highly important consideration in the development of a court. If I overstate this, I do so only by a matter of degree. You see, the CCJ is fairly explicit about its symbolic role. It is meant in part to be a symbolic step in the closing of the circle of independence, the final step in a decades-long process of complete decolonization, a sign that a Caribbean court with Caribbean judges who share the values and customs and beliefs of the Caribbean people will be developing a particularly Caribbean jurisprudence. To be seen to exclude certain members of society cuts to the foundation of what this court stands for. It is truly distressful then to know that certain groups felt and continue to feel this way. He subsequently, in 2014, he had another forum with the Mahasabha, and he advocated for members of the Indo-Caribbean community to apply for positions of judges in the bench. Now, the circle of independence, completing the circle of independence. I'm not sure I totally buy this one, because we have a political system that is Westminster. That is British political system we have here, no? That democracy. The only thing is they follow parliamentary supremacy and we follow constitutional supremacy. That's the difference. But we have a Westminster system, and it's causing havoc here because of our plural, very, very plural, small island developing state, okay? We have a legal system. Many of you here are judges. Common law, the British legal system. There has been no calls for delinking From that, right, there's been no calls for delinking from that. CXC, okay, so they are CAPE and the O-levels. We successfully delink, and there was no call, there were no major calls. I don't recall. I have been an educator all my life, and I don't recall high school, university, all over, and I don't recall that call, but we did it. We did it successfully, and there were no complaints thereafter either. There are problems internal with CXC, and sometimes, but those things are ironed out. So, I am wondering to what extent really is this a decolonizing project that we are trying to achieve, and whether we are lingering in the doorsteps of colonialism by adhering to the Privy Council, whether that is the issue. Is that the issue really? I'm trying to understand it because something is telling me something is wrong, and something is telling me something is wrong because I see Jamaica, while it has not gone Republican as yet. Barbados just went Republican, and the people are comfortable with that. Okay, and if diversity is the issue, the Indo-Afro divide in Trinidad, what is the problem in Antigua Barbuda? What is the problem in St. Vincent? What is the problem in St. Kitts? What is the problem in Jamaica? Right? So, I have come to the conclusion, and I have tons of stuff here on diversity, but I know I wouldn't have the time because I want to talk a little bit about those other islands. When we look at the referendum, Justice, you can turn to the referendum. There have been 8 attempts using referendums by different regional countries to abolish the Privy Council as a court of appeal, and all of them failed except Guyana. The process of amending the Constitution is sometimes complex, and it varies country to country. So wait. So here I'm bringing in the issue of constitutional amendment, which means that the politicians have a critical role to play. In other words, this debate has to go to the parliament, and this debate has to play out. Okay? Now, you don't have the constitutional majority, so you need the opposition. Hardly any of them have it, right? You need the opposition. So you need the opposition support. And when the opposition in power, they don't want it. And when they're in opposition, they want it. So we had governments changing their position depending on whether they were in government or whether they were in opposition. I'm a political scientist, so I pick up these things very easily, right? And I like to read these things. This is very interesting to me. Keep me alive. So Jamaica, Section 110 of its Constitution creates the right of appeal to the Privy Council. Section 49(1) of the Constitution enables the right of appeal to Privy Council to be amended if legislation is passed by both houses. Okay, now the Privy Council have actually ruled against Jamaica delinking from the CCJ. Yeah? They had a matter going there. Then, can we get the table with the results, the referenda results? I think it's the next, yes. So here we have the results of the referenda. Jared mentioned them, but here we have the results. We have 44% for and 55% against in St. Vincent and the Grenadines, 2009, 43% for and 57% against in Grenada, 2016, 45% for and 55% against in Grenada in 2018, and 48% for and 52%, now very close. But like I said, I have been looking at all these data, and I'm wondering, because we presented in Denmark, I-courts. They have an institution in I-courts there. And I presented on this and talk about this whole ethnic diversity issue. And they are insisting, they say it has something to do. They are experts, they have been publishing a lot of stuff. They are real academics. They are dishing out papers after papers on every court in the world, including CCJ. This fellow named Salvatore and Professor Marsden. So we're looking at this, and I realize from my own experience with my students and talking to people, this is a middle-class debate. This is a middle-class debate whose vocation it impacts. Academics, attorneys, judges, members of the judiciary. This is a middle-class debate. Go out in the street there and ask people, what you think about the CCJ? You know what they're going to ask you? CCJ who? CCJ what? So my students, I teach public international law, I teach Caribbean international relations. Even in my Latin American class, I bring it because I do comparisons. and I asked them, just as a little survey question, standing in front of them, so what do you all think about the Caribbean Court of Justice? I'm not even asking them if they know what it is. And they say, Miss who? What? What court? Third-year students, final-year students of the University of the West Indies studying public international law. Now they take up this course as part of our international relations program. I don't know if it will be different with the faculty of law. I'm not sure. But I can tell you the engineering and the science and technology and agriculture and humanities and the other faculties we have there, I am not sure anybody know what we're talking about. So you put this now to the population in these countries, referenda, let the people talk, right? Let the people have this say. The voice of the people is the voice of God, okay? I subscribe to that, by the way. I subscribe to the voice of the people. But the people don't know what they're voting on, like Brexit. This is a Brexit vote. A lot of that could be Brexit vote. And just as turn to the Trinidad and Tobago pie chart I have there that Dr. Ghani did recently, and somebody mentioned it, right? Yes, so just going to finish. Yeah. Professor Ghani did this poll, right? And what we are seeing here, and this is very recent. Now, he did it in marginal constituencies. Now, that's good. That sample is good because they mix up, they seriously mix up, ethnically and in every other way. And class and gender and everything, they seriously mix up. So I had no problems with that. So what were the results there? We had, this is so fine. 30% don't know, 25% yes, and 45% no. The 30% don't know, they really don't know what we're talking about, what he's talking about. They really don't know what he's talking about. Okay, so the referendum is not that the people want the Privy Council and they don't want the CCJ, okay, or that they're rejecting the CCJ categorically. The results of those referendums, I want to say, is that the people don't know what CCJ is. And many don't care either, right? So now, we want to get now to the other point. So Dennis told me, and I'm going to divulge this, I'll have to apologize to him, that he was in a conference with us in October, the ADR conference, which we organized, and Sir Dennis was one of our featured speakers. And Sir Dennis said that, some people coming to him, somebody came to him and said, it's the Indians in the country don't want the CCJ. And Sir Dennis turned around and told him, that is not true. So the person was totally baffled because they were saying that it's the UNC leading the Indians to not want the CCJ, right? That's a perception, and it might be a misperception too, because there are senior counsels across the divide who don't want it because they go to London and they get handsome fees and they get a hotel paid and they get the trip. There is that. That's another middle-class group, highly middle-class group that has a deep interest in retaining the Privy Council. I have colleagues of all backgrounds across the divide because they've even made it a north-south divide, that people from south want Privy Council and people from north that is one CCJ, because this is the politics of the day playing out here. And we know Labre and Point Fortin and went UNC, and San Fernando East nearly went UNC. So those kinds of myths, even the politics of the day is dismissing them. That, the safe seats, now we wonder which one is marginal and which one is safe as political scientists, something we have to carefully rethink ourselves when we're looking at results, and Tunapuna and La Hoqueta Maloney going UNC easily, San Fernando West. So that's the politics. That's a different debate and something I have to discuss through my Department of Political Science. But what I'm trying to say here is that we interviewed Mr. Pandey for the thesis, and it's here. And I asked Mr. Pandey, I said, Mr. Pandey, you were the one who brought the CCJ, and you fought for it to have the seat of the CCJ in Trinidad and Tobago. Why are you now so opposed to it? Because you have made public utterances. I believe he called it the Caribbean Court of Injustice. Mr. Pandey, right? So Mr. Pandey, with his usual flair, the perception, my dear, the perception. And I said, Mr. Pandey, what perception? So he didn't want to elaborate, but he said, have you ever heard me in 2009 in Sangre Grande on a speech? I said, Mr. Pandey, no, I don't recall that speech, 2009, I don't recall. He said, find it and find out for yourself. You're a researcher, go and find out for yourself. So I did. So what happened? There was a run-in between Mr. Pandey and Justice Hayton. Right? Justice Hayton is a British judge. He was actually based at King's College. He's one of the leading practitioners in the law of trust. Brilliant, brilliant, brilliant man. I think he taught you justice, law of trust at conveyancing. And when he got the job, he actually did an interview saying with some law report in King's College that he had found the ideal job where he was under work, had time to play tennis, squash, golf, and if you reflect under palm trees. Pandey read out the whole Express. That day, the Express carried the story, June 30th, 2009. Pandey read it out on the platform in Grande, right? And then Justice Hayton went on to say that he doesn't see the country or the CCJ adopting the CCJ until the opposition leader, who was Pandey, ceases to hold that post. Hayton is also reported to have said that the CCJ would probably never replace the Privy Council given the political landscape in Trinidad and Tobago. So I think that was the seed. That sowed the seed of the mistrust, and this is what Pandey said. One wonders, given Justice Hayton's comments, whether a UNC politician or sympathizer can expect justice under the CCJ. How can we trust the CCJ? We have also seen where the conduct of the chief magistrate and other high office holders has brought the justice system into disrepute. Who can say that this would not happen again? He said that the nation has lost confidence because of government's interference and attempt to manipulate the system. Okay, so that's his politicizing and different issue. So the point that I'm trying to make is that you have to just be so careful of what you say, where you say it, because it can have long-lasting impressions and impacts, repercussions. They can have long-lasting impacts. So the smaller islands, and I want to also say this. So I think it's two reasons mainly. The lack of trust and confidence, if I have to summarize why, what is the root cause of that, because that is going to be the subject of the book. What trust, what confidence, why? I think it's a mistrust of also the judiciary. Jared mentioned it, the local judiciary, and the CCJ being part of it, and that goes across the islands. I also think in Trinidad we have these peculiar ethno-dynamics. There's been the gender dynamics being raised by the academics, not so much by the people, and not even so much by the legal fraternity, but by the academics, people like Tracy Robinson, and they reason that issue, the gender factor. I think that's also a problem. But I think the ignorance, the lack of knowledge about the CCJ, the lack of knowledge, people not reading them cases. Who going to read them cases? Seriously, the lay person, who going to read them? Why are they going to spend the time doing that? And Justice Rajnath called for people to read them. So it is after I have read it that I was convinced that this court, this court is solid. I could not find, I was looking for bias, because people talking about bias and perception, I was looking for it when I was researching. I could not find it. We surveyed more than 300 cases. In the original, there are 35, and there are 386 in the appellate. And that alone was enough to me, because if you have 5 countries bringing 35 cases, 386 cases, and 13 countries bringing 35, that should tell you something. The appellate cases come fast and furious. Justice Rajnath will know that. Every time I look, I see a new one there. I mean, by the day, you've seen a new one in the court's website. That court website has been a haven for me as a researcher. So now Prasad Bisesa, and I have to say this, I know it's going over time, but Prasad Bisesa has now assumed the Prime Ministership of Trinidad and Tobago. Okay, no secret, it's a fact. So where does she stand? Or where did she stand before? So she said in April 2012, Principal, you were there, it was the opening of the law faculty. She's announced that the time was ripe, as our democracy has grown in strength, to take responsibility ourselves for the final adjudication of our disputes consonant with the pristine principles of justice and fair play, and say goodbye to the Privy Council as our final court of appeal. She also stated that she would abolish the Privy Council as final court of appeal for criminal matters only. Now, why we didn't grab that and run? Why didn't we do that? We heard, I think Justice De La Basside said, you can't do that, half slave, half free. He said that don't work. The leaders, I don't know what the leaders in CARICOM had to do with this. I didn't know they were all legal experts, and they say you can't do it. I don't believe nothing like that you can't do. I don't see why we couldn't do it. We should have taken it, right? Because then they said that she wanted to make it a hanging court because she cited Pratt and Morgan, what they in the press conference, and bringing back those hangings and all that kind of thing. So we still have the death penalty in our book. This is not new. She said resume hangings. So these atrocious crimes and things. And by the way, the regional public has been for the death penalty. The research has shown that our regional public is for the death penalty, given the kind of heinous crimes that are being committed in the region. So, you know, after that, we see Vieira, independent senator, bringing it in the Senate. We see Regional Amo saying he was tasked with it. We see in former Prime Minister Rowley criticizing the Privy Council, especially after the visa issue. And, you know, it's left to be seen where this is going. I didn't get the statistics, but it is something I'm going to research. The UNC's brought a lot of cases against the former government, and they've been winning them in the Privy Council. So, as far as they are concerned, they get injustice there. If it ain't broke, why fix it, right? Now, they would say they don't know if they will get that justice. It's not that they're saying they're not going to get that justice in the CCJ. They don't know. They know they're not winning everything. Of course, you can't win everything. And it doesn't work so. We know that. It doesn't work so. So it's left to be seen what they will do. In opposition, they never really pushed for it. They never did. Whether they're in government and whether they're going to push for it in government, I don't know. It's left to be seen. So I think we have to continue the debate, not towards the end of having the country subscribe to the CCJ, but really to understand. We need to understand the Speaker Ronnie Yearwood spoke about these stories. All of these are stories, I'm telling you. These are the stories, untold stories. And when I say untold in the public, we have to dig up newspaper 2009 to find these articles. Because something was nagging me when Pandey was saying the perception, tell me, go and read that. And when I went and read it, I said, okay, this is the problem that he has. But there is a recognition by the current Prime Minister that accession to the CCJ is inevitable. And we might want to consider that good news. Thank you very much.
All right. So we can really notice that those with the pol sci background have a more impassioned approach to, you know, it's not strictly legal. But anyway, I wouldn't, excuse me. Yeah, so I want to now invite the Honorable Mr. Justice Osugi of the CCJ he would like to make a presentation to the audience here.
Well,
a contribution? Oh, okay.
Thank you very much. It's a great honor to be here. Now, I can assure you that I'm not going to enter into that debate. But it's been an exciting afternoon. Let me begin by sharing a few personal notes. First of all, as to my last name, if you can manage Ebo Suji, that would be great. But if it's difficult, you can just drop the Ebo part. You won't be wrong with Osuji. I understand there's been some people already who are familiar with that name in Trinidad and Tobago, so Osuji works too. The second personal note is to say that it's been very, very heartwarming since I've been here. The welcome has been phenomenal. nothing short of that. But then again, that's not surprising. I tell somebody, well, if you flew up and flew straight east, you're going to land in Nigeria eventually. And so this is like homecoming to me. People ask me, how have you found it? I say, well, it's good to be back to a place where it is warm, but people are warmer, and that is what it is for me. Now, I thought as an academic until recently, perhaps to share a few notes for the interest of the students as well as members of the public, to the extent that that might inform part of the stories of the CCJ. These debates, by the way, about whether to join an international court, it is healthy, but it is nothing new to the CCJ. The ICC, where some of you know I came from, there has been that debate out of the 192, 93 UN member states, 124 of them are member states of the ICC, and then you say, wow, 124. And then you go over to the ICJ itself, the older court since 1945. The compulsory jurisdiction of the ICJ, the jurisdiction that says if you are sued at the ICJ, you must automatically appear and not appear by consent of the other side. Only 77 of the UN member states have accepted that compulsory jurisdiction of the ICJ. So this continues to be an interesting debate along the same line as those other international courts. But as part of the story of the CCJ, I thought I'd contribute some perspectives about the kind of quality we have in this court. I started getting interested in it when, as an academic, I was doing certain research and I started reading the judgments of the CCJ. It was an eye-opening experience about the quality of reasoning. And then that took me to, okay, reflecting as somebody who used to be counsel before international courts, the International Criminal Tribunal for Rwanda. I used to be senior prosecuting counsel before that court, the Special Court for Sierra Leone. Again, senior prosecuting counsel, so I'm familiar with those. As an ICC judge, I had colleagues, my colleagues I worked with. I was familiar with judges of the International Court of Justice. I knew judges from the European Court and European Court of Human Rights, all those institutions, reflecting on the caliber of judges from those courts compared to the caliber of judges of the CCJ. I can testify to the fact that the CCJ judges, in terms of quality, are second to none as intellectuals, as lawyers. When you look at the bench, many of them have PhDs from some of the world's best universities, and many of them finished with first-class degrees. Some of them have both, finished with first-class degrees in their LLBs, as well as getting these kinds of high degrees from other international renowned universities around the world. So that is something to be said about the quality, the caliber, and integrity of judges. If you have that kind of caliber, that kind of background, you are not going to fool around with your judge or with your position once you're appointed in that kind of court. Second is perhaps the process of recruitment of CCJ judges. You don't have the rigorous recruitment process you now have at the CCJ. You don't see that in some of these other international courts. The ICJ, ICC is a matter of your country wanting you up there and you're nominated, and then there's some campaign done to have you elected, and you get elected. in those campaigns, you may need to be answering questions. Well, if you get this kind of case, how would you deal with it? You may get that. I'm not saying that happens all the time. But that is something you do not have at a CCJ, because you have a regional body of senior professionals. A lot of KCs used to be QCs, a lot of other professionals who, in the medical profession, accountancy profession, who take their work very, very seriously. They want to appoint the most competent, the most qualified people who applied to that court. And they do rigorous process of vetting their backgrounds before that job offer is made. You don't have that kind of system in the other international courts. And lastly, and I rest at that, when I was at some of you may know I used to serve as the president of the ICC. And in that capacity, every year, we had to appeal to states to pay up their dues so that the court could keep functioning. Now, the registrar of the court and now will go approaching, ambassadors and ministers, pay up the dues and all that stuff. That is a certain political vulnerability for a court like that. Now, there was a case, and I will not say too much about this, and a certain investigation in one of the hot situations around the world as we speak. ICC prosecutor was investigating, and the leader of that country said, well, you're investigating us? Well, I am going to tell my allies who are members of your court to not pay their dues to the court. That was said in public. That is something you don't get at the ICJ because of the system of funding of the court. CCJ. Thank you very much, Chief Justice. CCJ, because of the system of funding of the court insulates the court from that kind of interaction with states. So these are just a few thoughts I thought I'd share with you, and not to enter the debate on whether or not any state within the region should join the CCJ as in the appellate jurisdiction. And I thank you.
Thank you very much, Judge. Now, I'm sure everybody has a lot of burning questions or wish to make their contribution as well. What we will do is open up a Q&A that applies for both panels. And the panelists from the first panel will be invited to stay in your seats, and we will bring microphones to you all so that questions can be fielded. Now, it may be a short Q&A, however, it's going to run into our little cocktail time. So please do not feel that you're restricted in any way from engaging with the panelists. And I believe, okay, so Ms. Adana, Joseph Wallace. So the microphones. Yes, so we have ushers who will be taking the microphones to the various panelists and to the audience members. Anybody has any questions?
Just some comments. Dr. Michael Theodore, wow. Don't we feel sorry for the CCJ? I want to focus on the topic that we were assigned to look at, advancing the case for regionalism and indigenous jurisprudence. And as I looked at it, I asked, for what area? Is it for the Caribbean? And if it's for the Caribbean, is it the Anglophone Caribbean or the entire Caribbean, comprising the countries of the CCJ, which would include Suriname and Haiti, which are civil law countries? So that we cannot assume that because we are pursuing or investigating this issue of indigenous jurisprudence, that it has to be common law, because there's some very valuable lessons to be learned from civil law countries. The second issue that I looked at was, what is the meaning of indigenous jurisprudence? And we seem to think that indigenous jurisprudence, based on the topic and how it has unfolded here, is the sole purview of the CCJ. And I'm suggesting that indigenous jurisprudence have several stakeholders. One is one of the sponsors of today's debate, the University of the West Indies. And I put that in the context as well of the foundations of the study of law at the faculty of the UE, which, when the founders of Caribbean legal education sat down to discuss Caribbean legal education, they saw it as a combined effort of both the Faculty of Law at the UE and the Council of Legal Education, which they were engaged in. But apart from that, I have a very broad view of stakeholder interests. So I asked myself, in whose interest is an indigenous jurisprudence? And I believe that the primary stakeholder is the Caribbean people. So the question is, how do we engage Caribbean people in identifying what is the jurisprudence of the Caribbean? I have a definition of indigenous Caribbean jurisprudence as referring to a body of legal principles, doctrines, and interpretative methods that reflect the unique historical, cultural, and socio-political realities of the Caribbean, rather than merely replicating English common law traditions. Now, most of the panelists have already spoken as to the legal principles, doctrines, and etc. What I want to focus on in relation to indigenous jurisprudence is, how do we identify ourselves as Caribbean people? Because at the end of the day, the jurisprudence is for us, it should be by us, and it should be inclusive. And it goes back to the contribution of Professor Yearwood as to whose stories we tell. The Caribbean is comprised of peoples of African descent, Indian descent, Asian, and a smattering of other peoples from around the world. One of the very popular mechanisms of dispute settlement that is current nowadays is mediation. But do we know that mediation came out of an African system, traditional system of dispute settlement? So we import mediation as a principle of dispute resolution, but our people indigenously, organically, have had that process in them. So the same thing applies to the Paichan. The communal dispute settlements in India and so on and so forth. So that's one stakeholder. Second stakeholder is the institutional stakeholder interest in setting up indigenous jurisprudence. And I point to the Council of Legal Education, which was designed to do just that. Because I need to end, I would like to quote one principle.
Sure. And I believe CJ, the Chief Justice, may want to speak afterwards.
briefly. Mr. Theodore, perhaps, would you be okay with the CJ speaking while you look for the quotation?
Yeah. Oh, okay, I just found it.
Okay.
Another stakeholder is the legal profession, and the CRC was designed to produce lawyers with an acute awareness of the anatomy of his West Indian condition, with the vision and hope of the law reformer, and most importantly, with a deep sense of service to the law, to his client, and to his community. So I think that the legal profession has a critical role in that indigenous jurisprudence. And finally, Professor Marshall says, and this I feel is most important, our West Indian jurisprudence, when it comes, will be an amalgam of many elements, some taken from our former colonial masters, some from our fellow former colonials, some from systems other than the common law, and some indigenous. What is more, it will not rise up like a phoenix from the ashes of colonialism, but will have to be consciously created and industriously nurtured to the point where its content matches the description which we give it in anticipation of its fulfillment.
Thank you very much. Chief Justice?
Thanks. Let me just pick up from something that Dr. Theodore said. And I suspect we would find no disagreement in this room that judging is something that takes place in a political, social, cultural, and historical context. So the argument for the relevance of the CCJ over the Privy Council ought not to be a difficult one. But I think, as has been pointed out this afternoon, that's not really the argument. I mean, I think if you, to the extent that the public is a stakeholder, if you start asking them questions about Caribbean identity, they will say, what? Okay, because what they want out of a court is a felt sense of justice, of being heard, that my matter is dealt with quickly, and the problem I have is being solved. In that regard, there is very little trust. I think that is something that we have to accept. So the question is, in bridging the gap between us academics and intellectuals and lawyers about forging an identity, what questions do we ask our population to elicit from them the responses that will help us in this discussion about forging this Caribbean jurisprudence? But we cannot frame that interrogation in the language that we are using in this room. I am glad that we have the social scientists weighing in, because I don't think that's a question that lawyers can frame very well. And I'd be very interested in hearing comments of panel members as to how we might progress that interrogation.
Thank you. Is there any panelist who's willing to field this question from the Chief Justice? Is there any panelist who's willing to rise to the occasion? Dr. Rampersad?
So you're asking what questions we pose to the regional public? Well, first of all, I think we need to know whether they have ever heard about the court. And so that's the first question we might want to ask them. Do you know what Caribbean Court of Justice is? And what do you know about the Caribbean Court of Justice? So that would be a follow-up question to start with. And how do you feel about, you see, it would be difficult because then, like I said, many of them are ignorant about law. They're ignorant about courts. They may not even know about the Privy Council. okay? And the only thing they hear is what the politicians say on the TV, because that carry the most publicity, generally, what politicians say on TV. They're not going to be reading about this, the general public. So we have to start very, very simple. I think we have to start very simple, craft 5 simple questions to them. And how would they feel of having a Caribbean court as opposed to having a court based in the UK? But we have to keep in mind the Privy Council is not a UK court. It's the apex court of the appellate jurisdiction of these Caribbean states. So that is the other tricky thing. You will have to be explaining to them as you go along, I guess. And that is the difficult part with surveys and polls, because you're not there to explain. You're there to ask a question and get a yes or no, you know. So the problem with polling itself, and even polling, political polling, is difficult. And some say it's a snapshot in time, because a lot of times, sometimes they don't understand the question. A lot of times they lie. In small islands, people don't want to say who they're voting for. They don't. And they tell you one thing, and maybe 2007, the engineering department, GIS people were doing this thing digitally and then telling me COP going to win elections, right? When the history of it showed different, I'm telling them no, because I was going by the historical pattern. I said, no, it wouldn't happen. So, you know, so the polling itself presents a problem. Now, many of the politicians, Pandey, Ramesh Lawrence Maharaj, attorney, senior counsel, Kamala Prasad Bisesa, Prakash Ramadev, they've called for referenda. Our constitution doesn't have a provision for referenda, so they first will have to amend the constitution to go to referenda to the people, and then we will have to work out how we're going to ask the people what question. So it's not just we could just go and ask the people, just want to have a referenda. And I'm talking about an official referenda. What Professor Ghani did is he was polling on the politics, and he dropped that question in. Well, I think one of the answers that will come immediately is timely trial. So I've been presenting on the right of a timely trial on the CCJ, because like I said, that itself is a book, the amount of cases that the CCJ has dealt with this. Because 25 years and 30 years, some of these land cases in Guyana, you know, there's Trinidad as well, been taken to resolve. Then we have the death penalty cases. Okay, that's a different kettle of fish.
Okay, so Dr. Ramprasad has evoked some further questions. We have Dr. Yearwood and then Dr. Ali.
So Chief Justice, I don't, and this is where I think I disagree, I don't think we have to ask people about the court. I think that's the wrong question, because that keeps the debate where the debate is CCJ versus Privy Council. I think what we have to figure out are the values that people have, and then, exactly, and then we can align them, or rather the court will align with those values. And I think we probably know what some of those values are, but we're afraid to admit them because they probably show the worst instincts about what we think about ourselves. Death penalty, for example. So, you know, I mean, as you said, the survey showed that most people will be happy for the death penalty to continue. But then if we face that, what does that say about us as a Caribbean people? Are we inhumane? Are we uncivilized? So sometimes I think we know what the values are, but those values don't necessarily align with what a court will want to push as so-called progressive liberal values. So then maybe the courts are not a loggerheads, but the courts are going to a place where the people aren't yet. So the question is, how do the courts bring the population along to align with the so-called modern values? So when I ask what stories were the Caribbean Court of Justice telling, the Caribbean Court of Justice is probably telling stories that align to a future Caribbean person, because in some ways the stories about liberal values and rights, about LGBT community and trans, do not necessarily align probably with the Caribbean person now, but how do you get the Caribbean person to recognize and value the rights that the court is trying to assert? Because to be honest, if you probably ask the ordinary man on the street, they'll probably say pop the next 10 years or whatever. They're like 10 years delay. What that got to do with it? Because in their mind, that's where justice is served. So there's a disconnect between where courts and us as intellectuals, because we're trained to value these things, whether we went to law school that way or not. When we come out, we speak that language, and sometimes I think if we don't speak the language, the community around us will club us and judge us. So even if we don't like it, we speak the language and we walk the walk. Whereas the ordinary man in the street, they don't have to care. If you go back to, this is why I like what you said, that lawyers can't answer this. That's why I introduced Lovelace. Writers and essayists, they have the answers because they recognize where the ordinary man on the street is. If you read The Dragon Can't Dance, or you read any of Lovelace's, Salt, any of them, you see where the people are, you see where they're struggling with their community and their identity. And then I guess the question is then, how do the courts bring those people and help with that struggle? And maybe that's not even a court question, that's a political question, because then the dreams and the hopes of the people aren't being fulfilled. So then they see the entire system is flawed. So they don't just see the politics, they see the politics, the media, the police, the judiciary. Everybody's put into one basket. All y'all feeling me. All y'all feeling me. Look at the recent, not to extend the debate, look at the recent IDB survey on CHC results and the poor and the failings, the fact that literally our kids in the region can't read and they can't add, they can't do basic things. Look at all of these surveys. Look at the crime levels across the region. Look at the issues of poverty, household poverty growing in segments of the region, even though wealth in certain pockets may be improving. So then the court is really caught up in trying to address all of these issues through a judgment, and perhaps we expect too much of a court. How can a four-member panel court fix poverty or create a judgment that speaks to somehow the beauty of the Caribbean man and the woman and what they will become? But we, if judgments don't have that kind of language too, maybe we're to blame as lawyers. They're like, well, you don't do a good job. You're not speaking that, that truth or whatever we want you guys to speak. So in some ways, we have to take responsibility, I think, as legal professionals, perhaps for what we expect of the courts to do. And the courts have to say, perhaps, this is not our job. But the courts don't want to say that because the parliament's failing to do its job. So if the parliament doesn't do its job, the civil service isn't doing its job, some institution has to carry the burden. And right now, across the region, I think the courts are carrying a lot of the burden because you have a situation where governments don't want to take tough decisions, and then they leave it to the courts, and then the politicians go, well, the courts did it. I didn't decriminalize I didn't do that. It was the courts. And they're happy to shove it to the courts. And then the courts take it, and then they get the beating. And it's just a circle. So I don't know. It's a hard question, but I think we have to try to figure out where the value system of the people are, and then the courts will have to think, how do I get the people from there to here? And I'm not sure. We always do this in the Caribbean, mass education programs. I'm not sure that works. Town halls and radio ads and skits and leaflets in the mailbox. No, that's a waste of time. I think the way to deal with this is we have to really improve justice at the local level and improve people's lives, and then the rest of it will come along. But if you can't get justice at the local level, don't come tell me nothing about the CCJ.
Thank you, Dr. Yearwood.
That's a really comprehensive response. Only one thing I don't have the answer, but perhaps we should reflect on when you say how to get the people from here to there, or from there to here. Some may argue whether that's our job either, because are we reflecting then what is an indigenous reality, or are we bringing some kind of supposed international order by which we are redefining our reality?
Okay. Just to respond to something, two things. One is that the judgments of the court, I have a whole section in the book, and both jurisprudence, both jurisdictions deal with fostering a Caribbean jurisprudence, and the cases have raised those issues. The case law would testify to that. That's one, so it's there, right? But people are not reading the judgment. The ordinary people are not reading it. That's one. Okay. The second one, when you say the values of the people, which people? because our societies are we're plural societies. They're different groups, right? And I mentioned class, ethnicity, and they have even gender. They have different values. And particularly a society like Trinidad and Tobago. Now, Guyana, people ask about Guyana, but Guyana had gone because I think Burnham had abolished the Court of Appeal early in the game, and they had the Privy Council, and they had no choice. So that would have been a problem there too. However, the Guyanese, Indo-Guyanese that I speak to, and the last suite cases that came, during the whole Granger refusing to step down issue, which was also addressed in the book, they are very happy. The Guyanese people are very happy that justice is served, including the Indo-Guyanese, and they have a larger Indian population, proportion to population in Trinidad and Tobago. Very pleased with the judgments of the CCJ in those cases.
Thank you, Dr. Rampersad. Now we'll just go to Dr. Ali and then one member from the audience, and we'll move on because you have ample opportunity during the cocktails to continue your discourse. So, Dr. Ali?
Yes, I just wanted to add, you're asking about what questions, you have to ask questions of the people. What do they want? What are their values? The other end of asking questions is how do we let people know? Just even know what is the system that we're trying to get them to critique, to understand, to give us commentary. And I think having worked through the region, when you think about knowledge of the court or CARICOM, etc., maybe Barbados and Guyana have been most successful in maybe integrating it in their education systems, as opposed to Trinidad and Tobago and all the other countries. And if you don't view this as a fundamental part of your system, maybe we need to look at, just like we looked at when we were becoming independent and creating independent regional education mechanisms, whether for legal or CXC, etc., we need to look at what is our on-the-ground education starting, so citizens are empowered. So I agree with you that the mass education that Dr. Yearwood spoke about doesn't always work. The court has been doing a lot of public education, but do we have these concepts ingrained in our people to know that what they should expect from a justice system? Do they have the tools? Is this something we need to look beyond before they even get to university? It's something that we need to really build in. Otherwise, we will never get the kind of answers we want.
Thank you, Dr. Ali. And Dr. Rampersad did in fact allude to CXC and CAPE, and perhaps we could look into building it there so that our children grows with it. We have one question from the audience. I apologize for keeping you waiting. So.
Thanks, but Dr. Rampersad actually answered it, and the question was, segueing from Chief Justice, how do we get from where we are to where we would like to be? And I was going to ask her before she answered the question, how do you reconcile, because we have very similar demographic build, the situation in Guyana and Trinidad and Tobago, but I think you alluded to the fact that they had abolished appeals to the Privy Council, and so you answered the question. But still, even so, having that being an explanation, but how do you account for the distrust that there appears to exist here, but not there?
The distrust is not just an ethnic one, because it exists throughout the other islands as well. So, and I did say the lack of trust and confidence in the domestic judiciary. And this is being seen as the apex court of it is the apex court of a domestic judiciary. And that was the other one I said was ignorance. A lot of people don't know. I think those are the two overriding factors that I have surmised. I'm going to do some more research. I mean, when I write things in a book, I like to back it up. So I'm going to definitely do some more research. I want to get statistics. I want to get statistics on how many Privy Council cases people are winning, whether that is a reason that they're comfortable with the CCJ and with the Privy Council, but not sure about the CCJ kind of thing. And how can the CCJ convince them is another issue, And whether that is the job of the court, whether that is the task of the court to go about, blowing their own trumpet. That they have to be careful about that too. We have to, we have small islands, they have to be extra careful. Someone told me that our judges are not activists enough. That in Europe, the European Court of Justice, the judges are they advocate and they activists, but in small islands, everything becomes bacchanal. And we also have to keep in mind that we don't vote like we party, what David Rudder said. We don't vote like we party. I think Ronnie here would alluded to that. We don't vote like we party. Okay,
Thank you, Dr. Rampersad. Just one more question and
Yes.
we'll move on.
It's a comment, right?
Comment. Thank you.
I want to say that the CCJ remains, for me, an academic discussion, and as somebody said, a middle-class discussion. So that, and we keep saying that the man on the street doesn't understand about the CCJ. But from interacting with many people, a lot of people do not understand our judicial system. I was really surprised when an actuary who is a friend of mine asked me to explain what's the difference between a magistrate and a judge. Somebody, a very high official, asked me the same question. So it's not the man on the street doesn't understand. A lot of people do not understand our legal system. We leave it to journalists who want to sell their newspapers, or politicians to explain our judicial system to us. So we'll never get to the CCJ debate until and unless people understand our judicial system. So it might very well be that they don't care to understand, because I don't believe the brighter people in our society will tell me they don't know the difference between one judicial officer and another. So their main concern might just simply be, how do I get what I want out of the system? Or why am I not getting what I want out of the system? They do not understand our judgments. They do not understand what went on in a case. So they could leave our system, some people, saying it's unfair. So they don't care about the CCJ. They want to know, how are you going to take care of my legal needs? How do I get that? And I think that's why we'll continue to have this discussion at this level. But once we can't engage, not just the man in the street, but all those other very intelligent people who don't care, we need to get through to them and stop continuing this discussion as an academic one. We have to be very practical. And until they accept and understand our system, I do not think they will want to hear about the CCJ. They'll continue to say, I love what you said, CCJ what?
Thank you very much. So I'll now invite Mr. Marcus, also a lecturer at the Faculty of Law, UWI St. Augustine, to deliver the vote of thanks.
Good afternoon, everyone. I just decided to highlight 5 lines that stood out today just before I go into the vote of thanks. Creating an independent legal philosophy. CCJ is the embodiment of independence and sovereignty. Accessible, fair, and efficient justice. Get it right at the lower levels first. Law is shaped by where it's made and also by who makes it. And I'm sure for us, there are many other lines that stood out. Could I please invite us, first of all, to give a round of applause to everyone who participated today. Thank you very much, Dean, to you and your team, and just pulling together such a fascinating discussion. So it is my pleasure, on behalf of the Faculty of Law, first of all, to thank the esteemed panelists of speakers and presenters, the Honorable Madam Justice Rajnath Lee, the Honorable Dr. the Honorable Justice Anthony Gafour, Principal who's not here, Professor Rosemary Bell-Antwine, of course, the Dean and her team, Lynette Sibran-Sweet, Senior Counsel, President of the Law Association, Dr. Yearwood. Dr. Yearwood, you have really stirred quite a lot of discussion. And like I said to you earlier, you're built like an athlete, so I think you could take it when the pressure comes. Mr. Jared Jagru, Mr. Frederick Jilts, Dr. Indira Rampersad, and thank you for bringing together the skills of law and political science. As the Chief Justice said, that combination really adds a lot of value to this discussion. Thank you very much to the chairperson, Mrs. Shivanjali Ramuta, together with the moderators, Dr. Emma Perot and Mrs. Adana Joseph Wallace. We also want to extend our gratitude to our partners, the Law Association of Trinidad and Tobago, the Embassy of Greece, staff at the Faculty of Law who works very, very hard behind the scenes, the administrative staff in particular, staff of the University Inn and Conference Center, and those who would have been responsible for the cocktails that we have enjoyed, members of the media, and of course, you, the attendees, the participants who may have come from other parts of the globe who may have participated online. Thank you very much, everyone, for making this collective conversation a meaningful one. I wish you all, as you go, a safe journey to your respective destinations, an enjoyable weekend ahead, and if you can, please continue to stay for the cocktails. Okay. Dr. Ali, I missed you? Okay, even though I have it here, my apologies. And her office is close to mine, so that's not good. She will sort that out. Sorry about missing you. Thank you, Mrs. Wallace. So as we close, please enjoy the rest of the evening. Please continue to intermingle with the guests, and do have a safe weekend ahead. Thank you very much.